Good evening. So we're going to hear yours first. But I have to go through this first. Okay. Good evening. My name is Robert Cagnetta, and this is the meeting of the South Kingstown, Rhode Island Zoning Board of Review. Members present tonight are Thomas Daniels, our Vice Chairman, William Rosen, Kevin Diamond, and Arlene Hicks. Our alternate member, it's okay, Jeff Elia is here as well. And also present tonight are Amy Goins, the South Kingstown Special Legal Counsel, Jamie Gorman, the South Kingstown Building and Zoning Official, and Jessica Spence, the Administrative Support Associate. This board is made up of 8 people, with 5 of them regular voting members. A minimum of 4 members are required to be present to vote. In the event that regular members are absent or recused, an alternate member or members will step in. No more than 5 members are entitled to a vote. Tonight, the voting members will be myself, Mr. Daniels, Mr. Rosen, Mr. Diamond, and Ms. Hicks. Applicants here for either a variance, dimensional, or use, or to seek a special use permit. This board is a quasi-judicial body created by South Kingstown ordinance pursuant to state statutes. We don't follow strict rules of evidence, and we operate in what we believe to be in a fair and equitable manner. We try to let everyone speak unless they get carried away or it's determined not to be relevant. So in the interest of time, please try to be brief and on point. We do our best not to argue, and we keep things civil, and we try to hear the last petition before 10. When your petition's called, please come forward and clearly state your name and spell it for the record. Speak clearly so we can all hear you. You will then be asked to take an oath to tell the truth, and then you can present your petition along with any other witnesses to testify in support. The board will then ask you or your witnesses questions after the petitioner has presented their testimony. Anyone else with questions about the application or wanting to support or oppose the petition will then be asked to come forward. They will identify themselves, be sworn in, and present their testimony, which may be followed up by questions from the board. Please do not direct any questions to the petitioner or any other witnesses. The board will allow the petitioner to answer questions raised by the audience and/or respond to the comments after the comment period. After hearing all the testimony and before a vote is taken, board members will be asked to openly discuss the evidence presented. And so you're aware, variances or special use permits require at least 3 voting members to vote in favor of the petition for granting the requested relief. Board members will ask a lot of questions, and it's for good reason. We cannot grant just anything we choose. There are rules to follow per the South Kingstown ordinance, so you must give testimony to support either certain facts to allow your request to be approved. So tonight you're either here for a dimensional variance or a special use permit or an extension. For a dimensional variance, you must offer evidence to the board setting forth the following: that your hardship is due to the unique characteristics of the subject land or structure, is not due to the general characteristics of the surrounding area, that your hardship is not the result of any prior action on your part, that the granting of the variance will not alter the general character of the surrounding area, and that you must also show that the hardship that will be suffered if the variance is not granted will amount to more than a mere inconvenience, meaning that the relief is sought, that you're seeking, is minimal to enjoy reasonably the permitted use to which the property is to be devoted. So you guys are just here for a dimension. So with that, why don't you come on up, state your name, purpose, and
say.
So just say that again, so it's on the record.
Yes, certainly. My name is Patrick Doherty. I'm counsel to Gregory Rasso and Mariana Zotos with regard to a request for an extension of a year on the dimensional variance, which was granted on, received a letter dated January 9th of 2023. I submitted a timely request in November 17th of 2023, seeking this. The cause that brings us here is obviously there was a backlog of building projects as a result of the COVID. My client's preferred contractors were not able to get to it in a timely fashion. They had some discussions, and then they also got into the integrity of the structure as well. and they found some pretty compromised rot infestation on the wood sill, and an engineer has opined that it may in fact require complete demolition of the structure. We're still looking at our opportunities to keep what we have intact there, but we may in fact be back here for additional relief. But in the meantime, while we're evaluating that, we'd like to keep what we had alive in terms of the relief that was granted in the dimensional variance last year.
Okay. Thank you, Mr.
And my
Doherty.
clients are here
Oh, yeah.
to answer any questions if you have anything of them in particular.
Okay. And just so it's on the record, they did send a letter dated November 17th that you mentioned. And then we also have in the record the previous zoning decision, which is 3 pages, recorded, like you said, on January 9th, 2023. Now, is your intent, if the whole building is compromised and you're going to replace it, is the intent to sort of build it on the same footprint, or you're just not sure yet?
Not sure yet.
Okay.
We're going to try and comply as much as possible so that we don't have to seek additional relief. The architect has been working on plans along with the builder and the engineer. But as I did say, the structure as it stands right now, it was built as just a seasonal cabin home, and it's definitely not up to code. There's 2x4 construction. The sill is rotted. It's been flooded above the first floor in the past. There was rot and a lot of other challenges that really make this a difficult project. But my clients are, again, as they testified last year, this is their dream home. They drove by it year after year, and they always wanted a place on the pond. They fully intend to proceed forward and, make it a gem.
So, Mr. Gorman, if they do in fact find that the whole building is compromised and they decide to build on the same footprint, they would not need to come back, right? Or would they?
I guess it would depend if they plan on replacing in kind, or if they plan on enlarging it, the footprint, or up greater in bulk than what it was previously.
Okay. So the parameters would kind of have to be the same in terms of height, or under the height, and then on the same footprint?
Correct, and that'd be if it was damaged due to flooding or act of neglect or, hazardous, then it could be replaced in kind. But I mean, likely if it doesn't currently meet code, I'd be surprised if you're going to build the same thing, same location.
Even in the same spot, same height, all that freeboard, like the flood water or the FEMA regs and things like that would kick in as well?
Correct.
Okay. So more than likely they would need to come back unless somehow they were able to build exactly what's there.
Correct.
Okay. Does that make sense?
Yes, it does.
And that was kind of what they expected?
Well, I don't think they expected to find what came to light in the last year.
No. But there'll be degrees in terms of replacement. So, I mean, it's not about saving one joist and rebuilding the whole place is considered in kind, per se. I mean, you're essentially rebuilding it, so you'd have to follow new code and so forth. So there's going to be a level in which there's point of no return, almost, right? That they have to build something better?
It would have to meet current building codes, absolutely. But it could be the same footprint in the same location,
right?
In bulk.
Bulk. Okay, so meaning that if it's I don't recall the structure at all, but if it's a 1.5-story building, then it's a 1.5 story that goes back.
Correct. They wouldn't be able to do a 3-story on the same footprint without additional relief.
Okay. Mr. Diamond, you have a question? Yeah. Just turn your mic on.
To this, there we are. Wow, these are nice. This is a real upgrade.
Nothing but the best here in this game.
Wow, that's it. We're looking good as a unit here. So, is there a limitation to how much must be kept when going back and sort of solving by subtraction before solving by addition that they should be aware of? Like how, if they're going to start over and rebuild in kind, is a certain percentage of the foundation have to remain intact?
I don't think it's a percentage. I think the ordinance allows a replacement in kind if it's damaged or if it's beyond an accident, act of God, or if it's beyond repair due to damage, hazardous in general. I mean, it would be up to the burden of the owner and in his and her team to prove that it's, that's the case.
Okay, got it. Just trying to make sure that everyone understands sort of what the rules were on that, because I can see that being a gray area.
I know we deal with it all the time.
I ask because jurisdictions look at it differently and different ones, and I get that question a lot, and I'm just curious how that would be interpreted by the AHJ, which is you. So thanks.
Well, I do know also that the architect, Frank Karpowitz, who's in South County Commons, has been in to speak, or maybe by phone or not, has spoken with Mr. Gorman, and we have engaged the Trinity Engineering Group out of Providence, who's opined, and they'll be working to come up with a plan that, is most feasible, and if we have to come back here, we'll have to come back here.
Okay. And what you're looking for is a 1-year extension?
A 1-year extension of the relief that was previously granted.
Okay. And we're limited to a 1-year extension?
Yes.
Okay.
At this point, they can work. Sorry. Yes, we're limited to a 1-year extension at this point. If they need a second 1-year extension, they can ask at that time.
Okay. And we would do it from the date of the previous filing?
Yes, it always, the initial deadline starts running on the day of recording.
The day of recording. So January 9th, so we're going to January 9th, 2025. Okay. Any other questions, board members? No? Do you have anything else to add?
Nothing other than my clients are here if you have any questions of them.
Do you guys want to speak at all? You don't need to, but if you want to. No, don't. No, it seems pretty straightforward. So everybody okay with this? I don't see any particular issue with all the reasons that they stated. Seem pretty reasonable. So, okay. Thank you.
Thank you. Shall I turn the microphone off?
Sure. They seem to be pretty good at not picking up a lot of background noise. So, all right. Anyone want to make a motion to approve the extension till January 9th, 2025?
Thank you, Mr. Chairman. Move to extend the petition of Gregory Rosso and Mariana Zotos that was previously approved by the zoning board back in the end of 2022. Extend the dimensional variance 1-year extension until January 9th of 2025. We heard from the attorney for the petitioners, and certainly the reasons are there for granting the extension, and I move that we grant it.
Motion was made by Mr. Daniels. Can I get a second?
Second.
Second by Mr. Rosen. Any other discussion? Hearing none. Mr. Daniels? Mr. Rosen?
Aye.
Mr. Diamond?
Aye.
Ms. Hicks?
Aye.
Mr. Cagnetta? Aye. Motion passes. Good luck. Yeah, of course. No problem. So do I have to officially close the meeting? No. Okay.
We're still open, and if you want to stick around for the training, but no offense taken if not. I don't think you need it, right?
Probably not.
You want to? Yeah.
Thank you as well.
Okay, so now we're on the training session portion of the meeting, and this fulfills, I want to say, 2 birds with 1 stone. One, it will fulfill or start to fulfill our local requirement in the ordinance that the board complete a certain amount of training. That's been on the books for a while. Some years we do it, some years we don't. But for, I want to say, a year, maybe 2 years now, the state has adopted a training requirement for all planning board and zoning board and historic district commission members that you complete some kind of continuing education course, which the state developed in 2022 and 3, and then they kind of had to throw it out and start from scratch once the new laws were adopted that are now effective, or most of them are anyway. So some of you may have seen these laws already. Some of you may not. You should have all probably in the summertime received a memo from our office on these laws. I'm going to try to keep it tight at maybe a half hour. We're going to go through and focus on primarily the changes to the Zoning Enabling Act. And thank you, Jamie, for putting that on the screens. And I'll just kind of walk you through it, okay? Section by section, just so you can see what has changed. I also want to point out, if any of you want to review the laws yourselves on the General Assembly website, feel free to do so. Just note that the way that the General Assembly has linked them on their site, they have the old alongside the new. So, and I don't know if that will change at some point now that we're in January and the laws are effective now, but you'll see some sections of the Enabling Act are noted effective until January 1st, 2024, effective after, January 1st. So make sure you're looking at the right version. The role of the zoning board has been changed a little bit, but not so significantly. The role of the planning board has really been changed, but since you're the zoning board, we're going to focus on what you deal with. And I'm just going to go through this page by page. It's about 10 pages, but first, let's see if you can scroll down, Jamie, to the definition of dimensional variance. That's a few pages down. Yeah, it's under variance and then dimensional. Sorry, I should have specified that. You can see this was kind of just a cleanup housekeeping change, right? The definition used to be right in the definitions section. Now they've crossed that out and they've cross-referenced you to the appropriate section. So we'll go through that. If you keep scrolling down, when the definition section that ends, 45-24-38, there are new rules on substandard lots, okay? Oh, here's the other thing I should mention. If you all have a printed copy of the zoning ordinance, and Jess, did they have the version that the council approved on December 11th? Okay, good. You'll notice that it's MuniCode, right? MuniCode is our local vendor. If you go to MuniCode and look at the electronic version of the zoning ordinance, you'll notice the recent changes that the council adopted in December, effective January 1st, along with these new laws. Those haven't been incorporated into MuniCode yet. So just be aware. I often refer to the electronic version of the zoning ordinance because it's easier for me in terms of searching. But the paper version that you have is the version you should be looking at. And to the extent that further amendments might be coming down the line, those will be provided to you when they're available. Okay, so we already had reduced setbacks for substandard lots, right? Lots that are smaller than the minimum lot size for whatever zone they're in. We had reduced setbacks that were just reduced uniformly. It didn't matter whether the lot was a little bit undersized or a lot undersized. This new section, what the state has done with this new section is said cities and towns now have to adopt proportionally reduced setbacks. That means that if the lot is half the size that it should be, the setbacks are basically reduced by about 50%, okay? So this is intended, and all these laws were passed and they were billed as what Speaker Shekarchi called the housing package, right? And the idea was stimulate housing development and housing production. But notice this isn't just about residential development, right? This applies to these bills. Many of them will spur housing production, but they go beyond that as well, okay? So notice where it says a substandard lot of record shall not be required to seek zoning relief based on failure to meet minimum lot size. The setback, frontage, and or lot width requirements for a structure shall be reduced, and the maximum building coverage requirement shall be increased by the same proportion as the lot area of the substandard lot is to the minimum lot area requirement. And doing the math on this can get a little tricky, and that's why I'm glad that I'm not the frontline person. That's Jamie's job. But basically, think of it as a building bonus. So you get a bigger bonus if your lot is very undersized, right? Okay, so you get your setback shrink and your building coverage, your maximum building coverage percentage increases more if your lot is really small, because otherwise a really small lot is difficult to build on. So that's before it gets to your desk, right? That's when someone comes to the town saying, I want to build on this lot, those new setbacks automatically apply. And we'll get to next, or at some point, modifications. So reduce setbacks for non-conforming lots is step one. Then we'll get to modifications, and then if it still needs relief, then it will finally get to your desk. And notice it says, if you need further relief from those reduced setbacks, then you would apply for a modification or a variance. All right, if you scroll down a little bit further, Jamie, to the subsection C of that same statute, there's a prohibition on lot merger. In South Kingstown, we have a lot merger provision, right? If you own two adjacent undersized lots, they're automatically combined. We have a merger exception in our ordinance that was already on the books. Now, this addition to the law provides that lot merger shall not be required when the substandard lot of record has an area equal to or greater than the area of 50% of the lots within 200 feet of the subject lot. So that's another calculation that's required. And I'm hopeful that the applicants will provide you the calculation and then have you double check it versus you doing the math initially. But basically, the intent of this is saying you shouldn't merge lots when they're surrounded by lots that are similarly undersized, right? If you're an island, if you're a small lot surrounded by conforming lots, then the lots will merge. But if more than half of the lots in that 200-foot radius are around the same size as your lot merger won't apply. I do have some questions about kind of whether this was intended to undo mergers that have already taken place. And the answer is, with many of these laws, some things were spelled out clearly and some things weren't. And I don't know if questions have arisen yet, but I just want you all to be aware of what changes were made at the state level. And backing up a little bit, the town council adopted amendments to the zoning ordinance on December 11th that, put these state amendments into effect in our local ordinance. So that will be in your printed copy. Okay. This next provision, 45-24-40, we didn't change anything in response to this amendment. The state law already provided that if you grant a variance or a special use permit, it does not acquire the rights of a non-conforming use. Non-conforming uses have certain rights to expand, right? They can expand, at least in South Kingstown, we can expand a non-conforming use with a special use permit. This just clarifies that unless the municipality specifically allows a use that it is existing by virtue of a variance or special use permit, it doesn't acquire the rights of a non-conforming use. There's not much more to say about that one. We didn't change anything in our ordinance in response. Here's the meaty stuff on variances in the next section, 45, 24, 41. you can scroll down to subsection D, the standards for granting a variance. And here's where you can look at your templates that, thank you, Jess. I think Jess passed out the new templates for your decision. If you have your old templates for variances, you can throw those out because some things have been changed. So notice subsection D2, the state has struck the requirement that the hardship does not result primarily from the desire of the applicant to realize greater financial gain. That is no longer in the law. It's no longer something you need to consider. And I think the intent of this, I guess it doesn't really matter what the intent was. It's not in the law, but I think the intent was sometimes boards would get hung up on this requirement because if you're a commercial property owner, you can make the argument that everything you do is for financial gain, right? So boards would get hung up on this sometimes. This, I think, just relieves the attorneys and the board members from having to do some kind of mental gymnastics, right? But the bottom line is, don't think about financial gain anymore because it's not part of your calculus. Okay. Relief to be granted is the leaf release necessary. That is also no longer a consideration when you're considering variances. And these standards are for dimensional variances and use variances. Least relief necessary, again, some boards, not necessarily this board, but some boards would say, well, if you're asking for, say, let's say the setback was 20 feet, they were asking for 10. Can you live with 12? Well, if you can live with 12, can you live with 13? It led to some kind of splitting of hairs, and I think that's why this requirement was stricken. Finally, the dimensional variance standard was, I wouldn't say changed, I would say it was clarified. So scrolling down, in granting a dimensional variance, the standard is still more than a mere inconvenience. So the standard hasn't been changed, it's just been clarified. So what does that mean? It means that the relief sought is minimal to a reasonable enjoyment of the permitted use to which the property is proposed. So the key word here is it reasonable? Don't conflate beneficial use with reasonable enjoyment. If you look at subsection 1 directly above subsection 2, you see there's no change to the special standard for use variances. We see use variances very infrequently down in South Kingstown. Other boards consider them much more frequently. And the standard for a use variance is intentionally higher. You have to show that the property will lack all beneficial use unless the use variance is granted. So lack of all beneficial use is a high standard, and below that standard is mere inconvenience, which means reasonable enjoyment of the permitted use. So your template now reflects the new standards. Special use permits. That template hasn't been changed, but I have some caveats on it, okay? So notice that under B1 of this law, 452442, where it may was crossed out and shall was added, the may clause was added in 2022. So in 2022, the state says, well, if cities and towns want to provide a procedure whereby someone can come to the town and say, I'm proposing a use that's not listed in your table of uses, can you tell me whether it's close enough to a listed use that's permitted by special use permit that I can skip the step that would otherwise be required, which is going to the town council, getting the zoning amended to address that use, then I finally would go before the zoning board. So that procedure was intended to make it easier for property owners to come forward with uses that weren't contemplated. One example I can think of that we had locally was something like a doggy daycare facility. It wasn't specified in our ordinance. We had a kennel specified, but this was a little bit different. So I think the procedure at that time was going to the council, getting the zoning amended, and then finally coming before the zoning board. Now you see it's a requirement that our ordinance have a procedure whereby a proposed use that's not specifically listed can be presented to the board or the zoning official, basically to say, is it close enough to something that's listed? We already had a provision like this on our books, a provision whereby the zoning official was empowered to determine whether a proposed use was substantially similar to a listed use. So that provision of the ordinance has just been tweaked to conform to this section. In the next, in subsection B3, you can see state law already required us to establish criteria for special use permits, and those are the criteria that are set forth in 907. Some uses in our ordinance have very specific criteria, and some of them that you may be more familiar with are the criteria, for example, a special use permit for occupancy by more than, is it 3 or 4? Occupancy by more than 3 unrelated individuals. You're familiar with those criteria because that amendment to the ordinance specified very specific criteria. The state has now said it's not enough to just list a use in the use table and put S next to it. For each category of uses, you now have to have specific and objective criteria. And notice it says, in no case shall any specific and objective criteria for a special use permit include a determination of consistency with the comprehensive plan. So, your template for special use permits still includes that criterion. However, I have to advise you, we can't deny any application for a special use permit based on inconsistency with the comprehensive plan, because the state has told us we can't. I have no issue if the board wants to make a positive finding on that criterion. If you're about to grant an application, I have no issue with you making that finding, but I need to put you on notice that the state has now said that doesn't count as specific and objective criteria for the issuance of a special use permit. And let me back up a little bit. Special use permits, they're different than variances, right? A variance is the ordinance says X and you want Y. A special use, so it's permission to depart from the literal requirements of the ordinance, whether as to use or dimension. A special use permit is the town council who adopts the zoning ordinance has determined that this use, whatever this use is, in whatever zoning district it's proposed in, should be permitted provided that the listed criteria are satisfied. You can think of it as a use that's conditionally permitted, and if the boxes are checked, the application should be approved. So it's really a special use permit. It's important to understand the bar for a special use permit is intended to be and legally is lower than for issuance of a variance. Your job is to review the application against the listed criteria and determine whether all the boxes have been checked. And if you keep scrolling down to subsection C, notice it says, if an ordinance does not expressly provide for specific and objective criteria for the issuance of a category of special use permit, such category shall be deemed to be a permitted use. That explains the changes to the use table that the town council made in December. Many uses that were previously listed as S are now listed as prohibited. Some of them were also changed to permitted, but due to resource constraints, it was difficult for the town in the limited time we had between the enactment of these laws in late June and their effective date of January 1st, it was difficult to come up with specific and objective criteria for each and every use listed. So the use table was changed in the interim, but the planning board and the council, I think, were on the same page that at some point the use table might need to be further amended and criteria need to be developed. I should also mention, back in December, the council asked for a draft correspondence to be reviewed at their meeting on January 8th, requesting that the General Assembly consider delaying the effective date. So at this point, the laws have gone into effect, but the council was looking for correspondence that they could approve that would essentially request that the General Assembly give us more time on these laws. The January 8th meeting didn't happen, but at some point the council will be reviewing that correspondence. And you've probably heard in the news that several other communities, many other communities have these same concerns, right? Okay, how are we doing on time? Let me try to wrap up in the next 10 minutes. Modifications. Modifications, think of a modification as a mini dimensional variance. So we already had modifications on the books. They weren't utilized too often. We already allowed dimensional modifications for certain dimensional requirements up to 25%. So what was changed was really just the procedure and the standards. And now modifications are mandatory statewide. So some towns, if the setback requirement was 10 feet and you were looking for 9.5 feet, you still had to go to the zoning board. Now in South Kingstown, just as before, up to a 25% modification of the dimensional requirements is automatic if certain standards have been met. And we can scroll down and review those standards. They're similar to standards for a variance. The modification requested is reasonably necessary for the full enjoyment of the permitted use. If the modification is granted, neighboring property won't be substantially injured. The modification requested doesn't require any variance of a flood hazard requirement unless the building is built in accordance with applicable regulations, or no issues with respect to freshwater or coastal wetlands. If the modification requested is 5% or less of the applicable requirement, the zoning official can approve the modification without any public notice. If it's between 5% and if it's greater than 5% up to 25%, the modification has to be published in the newspaper and adjacent property owners notified. If any of the adjacent property owners object, just as before, the modification request comes to your desk as a variance request. So you can see the notice period was shortened from 30 days to 14 days, but modifications are basically the same. So that's the end of the changes, and you can see, just if we scroll to the end, that's the end here. The changes take effect January 1st, so these are all in effect now. The other things that you should know about that I'll touch on briefly, I know I've mentioned them before, but now that they're in effect, I'll mention them again. You're familiar in the past with applications that would come before you after they went through development plan review by the planning board. That's not going to happen anymore. If an application requires review by the planning board, they get to put on your zoning hat and review it under unified development review. So whether it's a land development project, a subdivision, or a use that's permitted but requires development plan review, any zoning relief is done by the planning board. There's no more two-stage, there's no more, you have to go to the planning board, then you have to go to the zoning board. Also, some of you may be familiar with reviewing planning board decisions sitting as the Board of Appeal. That's not going to happen anymore. If someone wants to appeal a planning board decision, whether it's approving or denying a development application, that goes directly to Superior Court. You do still have, and you're going to see shortly, we're going to get into an appeal from the zoning enforcement officer. You still sit as the Board of Appeal for those decisions, as well as for certain decisions of the administrative officer. For some reason, you still retain a little limited authority on planning-related decisions, but just not planning board decisions. Notice requirements have been changed a little bit. There's no more certified mail notice. All our notice is by first-class mail now, with an affidavit of mailing. So there's no more green cards. The cost is reduced. Newspaper notice is still required. Website notice, which we had already been providing, we certainly go above and beyond what the law requires us to do in terms of notice, providing public access to the applications and the correspondences received. Now that's mandatory. So towns that didn't have zoning applications noticed on the website now need to. It's 6:43, and I want to make sure we have enough time for a break, but any questions about anything else I haven't covered that you may have read? I could make this a 2-hour class, but we don't have all night. So, yeah. Mm-hmm. Mm-hmm. Mm-hmm.
So with this new law, can the building official go down to 3.75 on that?
Great question. Great question. The answer is no. If a property has already received a dimensional variance, they're bound by that dimensional variance. The modifications only apply to the dimensional table that's listed in the ordinance, not the dimensions that this board has, however many years in the past, applied on a variance application. So the modifications are only to what's listed in the ordinance.
So in fact, if this only wanted to go another 4.5 years, it comes before us.
Yes. Yep. You'll also notice, and you'll see on the agenda, we received some applications in, was it November? Yeah, so some applications, remember, we didn't meet in December. Some applications were received in November, before the council had the public hearing on the new zoning amendments. And staff reviewed the applications and determined they no longer needed relief under the new laws, right? So we can start the meeting with a note. If anybody is here, and that's already on the website, it's on the agenda, there's documentation from staff explaining, hey, these applications were noticed, but with these new laws, they no longer need relief. So at some point, if people talk to you generally, you're not supposed to talk to anybody about specific applications, but if people say, hey, I'm noticing a lot of development that I think, should have been publicly noticed, but notice isn't going out, you can kind of generally explain to them any questions. Staff can provide detailed answers. But in general, the new state laws shrink the category of applications that require a public notice. Anything else? I didn't even get to adaptive reuse, but let me mention that. That's a separate law entirely, and we don't have to go through it in detail, but what the adaptive reuse law is, it is an amendment to the Zoning Enabling Act, but they did it as a standalone law. Typically, commercial buildings, right, in commercial zones, if you wanted to put housing in there, you would need a variance. If residential use wasn't permitted in the zone. The adaptive reuse law says commercial buildings, offices, churches, malls, etc., can now be converted to residential use as a permitted use, so as of right, with no zoning relief required. There is some local review that will be required. You need to stay within the existing footprint. You need to go through the local process, and that may be land development project approval, that's review and approval, minor or major, depending on how many units you're proposing. But the key is the use is allowed. So that was specifically intended to spur housing development. The ADU law was amended in 2022. That was the one bill that didn't get enacted in 2023. so further changes to the law, but it's been signaled, the speaker has signaled it's a priority for him to pass this year, so don't bother getting too much into ADUs. What's on the books now may very well change by July 1st. Yep. Well, the General Assembly usually tries to wrap things up by July 1st, so, we'll provide an update to you on the laws if anything changes, but that's it for now. Sure. Yep. Mm-hmm. Yes, and the thrust of the state laws were to streamline and standardize development applications, so chipping away a little bit at local control, right? Like the adaptive reuse law, it wasn't an option for municipalities, it was, this is the law, there's no getting around it. Yep.
So we just don't know what the impact this might have on the when you're sort of taking those fringes, because if you can expand non-conforming by 25%, that would be pretty significant in the area that is pretty tight.
Well, let me clarify for the modifications. If it's a non-conforming use or structure, that's subject to our existing special rules on expansion of non-conforming uses or structures. The 25% modifications are just for dimensional requirements. If there's a non-conforming use existing on that lot, those rules still apply. Yeah, I should have clarified that.
So that's interesting. So that becomes something more for the building inspector to be able to sort of make these judgments on these things that are. So is this on like any lot? It's not 25% within the dimension. It's just those non-conforming dimensional.
Okay, I talked about two things pretty close together, and I want to make sure we can keep them separate. So one is proportionally reduced setbacks for non-conforming lots, so undersized lots. That's only for undersized lots where you're seeking to build. The next thing is dimensional modifications. So if it's a non-conforming lot, the setbacks are proportionally reduced, and then a modification could be requested and would apply over and above the reduced setbacks. Only for that type of lot, yeah. But modifications are available universally. Modifications aren't available for creating a new lot. It doesn't apply to lot area. Creating a new lot is still a subdivision. You still go to the planning board. The minimum lot area for the zoning district still applies. But if we're talking about existing lots, setbacks, frontage, lot width, those can all be reduced by a modification, even if it's a conforming lot. I think examples will help as we start to see some of these applications come before us, but the examples are really going to come to the building official, and you may, at some point we might give some examples of here's what you didn't see, right? Exactly. Yeah. Yeah. All right. Thank
benefit of everyone is here. All right, good evening, everybody. My name is Robert Cagnetta, and this is a meeting of the South Kingstown, Rhode Island Zoning Board of Review. Members present tonight are Thomas Daniels, our Vice Chairman, Mr. William Rosen, Kevin Diamond, and Arlene Hicks. The alternate members of Jeff Elia is here. Also present are Amy Goins, the South Kingstown Special Legal Counsel, Jamie Gorman, South Kingstown Building and Zoning Official, and Jessica Spence, the Administrative Support Associate. This board is made up of 8 people, and 5 of us are regular voting members. A minimum of 4 members are required to be present to vote. In the event that a regular member is absent or recused, an alternate member or members will step in. No more than 5 members are entitled to a vote. Tonight, the voting members will be myself, Mr. Daniels, Mr. Rosen, Mr. Diamond, and Ms. Hicks. The applicants here are either for a variance or a dimensional or a use. For a variance or to seek a special use permit. The board is a quasi-judicial body created by the South Kingstown Ordinance pursuant to state statutes. We don't follow strict rules of evidence, and we operate in what we believe to be in a fair and equitable manner. We try to let everyone speak unless you get carried away or it's determined not to be relevant. So in the interest of time, please try to be on point and be brief. We do our best not to argue, and we keep things civil, and we try to hear our last petition by 10 o'clock. When your petition is called, please come forward and state your name clearly and spell it for the record. Please speak clear and loudly so we can hear you. You will need to then be asked to take an oath to tell the truth, and then you can present your petition along with other witnesses to testify in support. The board will ask you questions and your witnesses, and after the petitioner has presented their testimony, anyone else with questions about the application or wanting to support or oppose the petition will then be asked to step forward. They will be asked to identify themselves, be sworn in, present their testimony, which may be followed up by questions from the board. Please do not direct questions to the petitioner or other witnesses. The board will allow the petitioner to answer the questions raised by the audience and or respond to comments after the comment period. So after hearing the testimony and before the vote is taken, the board members will be asked to openly discuss the evidence presented. And so you're aware, special use or variances require at least 3 voting members to vote in favor of the petition for granting of the requested relief. Board members will ask lots of questions, and there's a good reason. We cannot just grant anything we choose. There are rules to follow per the South Kingstown Ordinance, so you must give testimony to support certain facts to allow your request to be approved. So tonight we have dimensional variances and special use permits on the agenda. For a dimensional variance, you must offer evidence to the board setting forth the following: that your hardship is due to the unique characteristics of the subject land or the structure. It is not due to the general characteristics of the surrounding area. The hardship is not the result of any prior action on your part, and that the granting of the variance will not alter the general character of the surrounding area, and that you also show that the hardship that will be suffered if the variance is not granted will amount to more than a mere inconvenience, meaning that the relief sought is minimal to a responsible enjoyment of the permitted use to which the property is proposed to be devoted. And for a special use permit, you must present the following: that you are not requesting, the special use permit that you are requesting is specifically authorized by the zoning ordinance. So somewhere in the zoning ordinance, it has to authorize that you can do it, or else we don't have the power to grant it. The special use permit requested meets all the criteria set forth in the zoning ordinance authorizing such special use, and that the granting of the special use permit will not alter the general characteristic of the surrounding area or impair the purpose or intent of the zoning ordinance. And if you have questions about any of this stuff, please just feel forward. When you come forward, just feel free to ask. So we have 3 things on the agenda here tonight. It is the first one is going to be the petition of Ted G. Tracy. of 25 Sonia Drive of Coventry, Rhode Island, 02816, seeking a one-year extension on a special use permit. Is someone here for that? No. Do they need to be? Okay. Okay. So I can finish reading this and then we'll, okay, got it. Because no one stood up, I was just. So the applicant was originally granted the special use permit on November 16th, 2022 to construct a 6-foot 9-inch by a 22-foot addition to the existing seasonal cottage. The lot size is 50.2 acres. The special use permit was required per the zoning ordinance section 203, special use permit for addition, enlargement, expansion, or intensification, section 608, the coastal community overlay district, and section 907, our standards of relief. The special use permit had a one-year expiration date from the original recording date of November 28th, 2022, in the South Kingstown Land Evidence 1846, page 209 and 210. The owners of the cottage, 13W4, are Ted and Julie Tracy on property owned by Matunic Beach Properties, located at 240 Cards Pond Road, South Kingstown. Assessors map 92-1, lot 9-359, and is zoned R200. For this petition, we do have the one-page letter dated November 20th of last year from Ted G. Tracy requesting that extension. And then we have the previous zoning decision, which is 2 pages, recording in our land evidence on November 28th, 2022, the book 1846 and 209, 210 pages. So we have, under Mr. Gorman, I'm writing in request to a one-year extension of the special use permit received on the 28th of 2022, November. Shortly after receiving the permit, the contractor we had planned to use dropped out, and we have spent much of the year trying to find a replacement. We are now signing with a new contractor to complete this project in February of this year. If you need further information, please do not hesitate to contact me. So you guys are aware this is one cottage on a property that has multiple cottages. It is in the coastal overlay district. It seems like that there wasn't any issue in the last time. Does anybody have any concerns about this or thoughts about the extension? Everybody okay with that? Okay. So they're requesting, so it would be November 28th, 2024. Okay. So I'll make a motion to extend the petition the special use permit of Ted G. Tracy to extend until November 28th, 2024. Yeah, and there's nothing else tied to it. So, can I get a second? Second by Mr. Daniels. Any other discussion? All right, hearing none. Mr. Cagnetta is aye. Mr. Daniels? Aye. Mr. Diamond? Mr. Rosen? Aye. Ms. Hicks?
Aye.
All right, the extension's approved. So next, we have the petition of Rose Delmonico, care of Michael O'Brien.
Mr. Chairman?
Yes.
I was just going to say the three that were, the three on the agenda that were no longer necessary.
Oh, yes.
Do you want to just see if anybody's here in the audience for that?
Oh, yeah, sure. I'm sorry. I apologize. We were supposed to go over that. I jumped right into
Just
that.
in case.
Yep. So, for those that aren't aware, there have been a number of changes in our zoning ordinances relative to the state passing a variety of new laws. And with these changes, there's going to be a number of applications that were once coming in front of us that are no longer having to come in front of us, right? So there were three in particular that were advertised. That we have the petition of Dawn Soro. Is there anyone here for that petition? No? That was a dimensional variance. And then we have the petition of Vincent Breslin. Is anyone here for that one? Which was another dimensional variance. And then a petition of Michael Sassy. Anyone here for that? Another dimensional variance. Is there something common between these three that we can just sort of explain why they're no longer, just quickly, or is it?
What they have in common is they're all substandard lots, so the proportionate reduction in setbacks that Amy was going over earlier are greatly reduced. So no longer would the additions and the projects that are in these applications would need any relief. In the event, they could actually construct likely larger additions and still not need a variance. So that's what they have in common, but proportionate reductions in setbacks due to the non-conforming lots.
So basically, these are lots that were too small for the neighborhood, that these folks had asked to enlarge their house. So the new law is allowing them to use extra space on that substandard lot that they normally wouldn't be able to, right? So if you happen to have a lot that's smaller in a neighborhood, then it allows you to do stuff without having to come in front of the board anymore. Is that good enough? Okay. So this is the petition of Rose Delmonico, care of Michael O'Brien, 358 South Road, South Kingstown, Rhode Island, 02879. They're here for a dimensional variance under the zoning ordinance as follows. The applicant is seeking to construct a detached accessory apartment with a building height of 22.1 feet. The maximum height allowed for the accessory building is 20 feet. So a relief of 2.1 feet is requested. Lot size is 2.24 acres. This is a dimensional variance required per the zoning ordinance section 401, schedule of dimensional regulations, and section 907 are standards of relief. The owners of the property of Theodore R. and Rose E. Delmonico for premises located at 366 South Road, South Kingstown, Assessors Map 55-2, Lot 27, and is zoned R80. For this petition, we have the application signed and dated on November 3rd of last year. Owner authorization form signed and notarized November 7th. RIDEM, on-site water treatment. Construction permit dated August 29th, 2023. A site diagram of A002 prepared by Unity Homes dated August 31st, 2023. Construction documents drafts, which there are 6 pages, prepared by Unity Homes dated August 31st. OWTS new design plan, 2 pages by Michael Fontaine, which is stamped on November 11th of 2023 and dated May 19th and May 22nd of 2023, revised on the 24th, June 8th, July 31st. There were also some revisions. Recorded deed restriction, 3 pages, recorded in South Kingstown Land Evidence 1859, pages 297 through 299. Exterior elevations, 1 page, prepared by Unity Homes and dated October 10th of last year. The 200-foot abutters list, legal notices, and notarized affidavit of mailing. And does this request fall under any of the new laws, or no?
We were just discussing that, Amy and I. So
Okay.
if it wouldn't fall under the 5% administrative review and potential approval by the enforcement officer, but it would qualify for the 25% modification
Right.
of the required, so they could go up to 25% in excess of 20 feet, so 24 feet, but that would still require advertisement, a butters notice, and if any objection letters received within that 14-day period, then it would then go before the zoning board,
If there was an objective?
if there was, correct.
So, or we just go through this tonight?
Or just go through it. I mean, it was submitted in November, so
Right.
prior to the enactment of the laws.
Right.
So I think, it's up to the applicant, but I would recommend that.
That they go through with it tonight, because they could not need to come here if no one objects. Did I say that right?
It would,
But they would have to advertise it again, and they'd have to
Correct.
wait all that, or they just kind of go through it tonight.
Yeah.
Yeah.
Because the applicants are here without a legal counsel, I want to make sure they understand what we're talking about. There are new state laws that just took effect on January 1st Your application was submitted back in November, right?
Yep.
So I think you have two options. Tonight, you can go forward with the variance request and have the zoning board evaluate what you applied for, which is a dimensional variance application, and you'll be judged by the application will be judged by the zoning board according to the variance standards. However, it's potentially eligible for an administrative modification where you wouldn't have to come before the zoning board. But you're here tonight, we might see if there's anyone in the audience who is intending to speak tonight. So I think the choice for the applicants is go forward tonight or request to continue it, and then they would have to start the process as a modification.
Okay, so let's first ask, is there anyone here for this petition besides the applicants out there? No? Okay. So basically, it's just a matter of deciding, you can finish this tonight, right now, or you can say, you know what, we're going to do it administratively, and it's going to take a little bit more time.
Okay, I think it sounds good to do it tonight.
Okay, great. So that being said, we're going to swear you guys in, so please just state your names, spell it, and we'll start with that.
Sure, go ahead, Rose.
Rose Delmonico, RoseDelmonico.
Okay?
Michael O'Brien, MichaelObrien.
Okay, and you both swear to tell the whole truth and nothing but the truth?
So help me.
All right, that's great. So, that being said, tell us what you want to do, just kind of go over, summarize what you want to do and why you need the relief you do.
Well, we're building an accessory cottage. It's for Rose's mom. And we exceed the height limit only in terms of the variance that we're looking for. Unity Homes, I'm a builder. I built a lot of their homes. They have standard models. They don't really change the model. So, my client really likes what they do as I do. I've been building them for about 10 years or so. They're, net zero, super insulated homes. And so rather than ask them to go through the whole rigmarole of changing the whole design mode that they're in, because the house is up in the woods, it's on a couple acres, really nobody's going to see it. I'm one of the neighbors. I had subdivided this property 30 years ago, maybe 40 years ago.
30 years when our house was
So,
built, 31.
So we just thought we'd try to, use one of their models.
Okay. And Jamie, or Mr. Gorman, if this were just a structure on the building that wasn't an accessory, what would be the allowed height for it?
35 feet.
35 feet. So we're at 20 because it's an additional dwelling. It's an accessory on the property.
It's an accessory building, correct?
Okay.
And
So
it's going next to a house that I built 35 years ago or something like that. I'm not
Pretty
sure.
close.
In 91, I think.
Yeah.
And that house is 34 and a half feet tall, so.
right. So and by no means this is out of the ordinary for its height or use. It's a two-story building.
Yeah, it's sort of a 1.5 stories, just a little bit loft area. But
Right.
it's one of their models that they presented, and rather than have them go through the design changes, I said, well, let's just seek the relief.
And I mean, in fact, you're not getting all of the use out of the second floor because some of that footprint is taken over by a slope ceiling
Exactly.
going
And
down.
actually, half the building is cathedral down in the lower level,
Right, and that doghouse dormer is sort of giving you a little more space on the
just to
second
get the
floor.
stairway in.
Yep. That's a stairway?
Yep.
Okay. And any other, anything unique about the site that's making you have to put it in that spot and you can't put it in a lower spot or a different spot
The
or?
land is kind of even in that area, but it is gently sloping, maybe about a 6 or 7% slope, but either way would be in violation,
So why that spot in particular on the property?
Because Rose wants her mother to be close to the yard.
It would make her share the yard with us,
With the
and
grandchildren
we
as
would
well.
share the driveway, so then we wouldn't have to put in a separate driveway.
So it's disturbing less of the land and so forth.
Exactly.
And the topography, sort of, it fits in that spot for you guys
Yeah, it's kind of just next to our house in the woods, kind of protected by woods all around it.
right. And I see the OWTS, which fits fine on the property. No issue
Yeah,
for
no
that.
issues there.
Okay.
The soils are generally the same throughout the whole piece.
Yep.
That you could put anywhere, but we had to put a new system in because we have an existing 5-bedroom system that we can't really tie into because the regulations changed on that, so we'd have to upgrade that whole system, which, quite frankly, it wasn't cheap in 1991, you know.
Yeah, they're not getting cheaper to dig a hole.
They certainly are.
And water system, it's all fine, like, you know, water the site and all that?
Yeah, served by well water.
Well water. Okay.
That's why my children are all taller than me.
That's good. You don't want them to grow second or third year or something like that. All right, board members, any questions for the applicant? Mr. Rosen?
One real quick, funky question.
Okay.
Your address is 366 South Road. There's no mailbox on South Road.
No, the access road, it's actually O'Brien Road because I put it in 30 years ago.
Yeah, and there's no label of O'Brien Road.
No, there isn't.
Until you go in.
Yeah.
Until you go in.
Yeah,
But
I
when you
wish
turn
we
in
were,
off South
yeah.
Road, there's a row of mailboxes. And so right on South Road, when we get mail delivery, there's a row of mailboxes it's always been that way, kind of deal. I was even hesitant about, I'm not that vain about O'Brien Road, you know, let's change it to something else, but it ended up that way, so.
Okay. It's just that I went out there looking for it, and
And you
I
couldn't
usually
find it.
look for
You
mailboxes.
have to go in.
You have to turn off
in.
South Road, but it's from me to you is the mailboxes,
Yeah.
once you turn off.
Well,
So we went to check it out.
Unfortunately, the snow prevented me from going up that road.
Right
so-
after the Stone Soup Way entrance. It's the
Ah,
next driveway.
okay,
It's the next driveway coming from town.
okay, thank you.
Sure.
No, no. Except the fact you couldn't find it. That's on purpose. They don't want anybody to. No, it's not true.
Just wonder how they got mail.
Okay, any other questions, board members? No? You guys want to add anything else?
I don't think so.
Nope. We're ready to build this thing.
Cool. So everything's ready to go, like you should be able to finish it in the time frame that we have, that you guys have to assemble this guy?
Yeah, absolutely.
Okay, good. All right, well, thank you very much. We'll see if anybody else has anything to say, but
Thank you.
We're good to go.
thanks, Rose. Thanks, guys.
Turn this off.
All right, I'll ask again, there's anyone here wants to speak on behalf of this petition? Okay. I mean, it seems real straightforward. They're within the footprint of the setbacks. It's a nice remote site. You know. Yeah, even the height, and I'm surprised that wasn't addressed somehow in the accessory dwelling, allowing them to go a little taller, but I guess that's not. No.
It's just a modular.
Right.
Yeah,
Yep.
Very human scale.
yeah.
Absolutely.
It's not super visible from the right away at all. So.
No, I think it sort of fits the accessory sort of dwelling, yeah, in a quite perfectly. Okay.
I like it.
Anybody else have any thoughts? No? Someone want to make a motion? Or,
I guess I'll do it,
all right,
since I,
with the new standards.
with the new mailbox.
Well, don't put that in the decision. You can't
No.
force them to put that.
Move to approve the position of Rose Delmonico and Michael O'Brien for raising the height of the ADU by 2.1 feet. Rose Delmonico and Michael O'Brien spoke before the zoning board tonight, and there weren't any questions raised by the committee, so we'll move forward. The board finds that the hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structure. I assume, before I get going, that I have to use the old cheat sheet, right?
Nope, new cheat sheet.
Oh, I used the new one.
Oh, yeah.
Okay, sorry.
Out with the old.
Out with it. But this is a variance from November.
So we have talked internally about what to do with applications submitted before January 1st, right? And in this case, we determined tonight they're potentially eligible for a modification. Many applicants delayed submitting applications until after January 1st. Especially, represented by an attorney. The attorneys knew, the new laws are coming down the pike, so don't put in your zoning yet. My recommendation, and that's what we're doing tonight, is we're applying the new laws, even though the application was submitted in November, because otherwise they're just going to pull it and then resubmit. And in this case, they even had the option of potentially submitting under the administrative path with modifications. So the board is going to see next week an application that was submitted in December, and we'll talk about the standards, but I want to get into it more specifically next week. But the short answer is apply the new laws and using the new template.
Okay. It's a shorter template, too. So, the board finds that the hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structure and not the general characteristics of the surrounding area, and is not due to the physical or economic disability of the applicant, excepting those physical disabilities addressed in 452430, paren 16. This is just an ADU being built for Rose's mother. It's going to be well back away from South Road. People won't even be seeing it. It's just a modular home that's going in there, and so there's no problem with this application. The board finds that the hardship is not the result of any prior action of the applicant. It's going to be a new structure that's going in there, and so there's no prior action to be dealt with here. The board finds that the granting of the requested variance will not alter the general character of the surrounding area or impair the intent or purpose of the zoning ordinance or the comprehensive plan upon which the ordinance is based. It's essentially going onto their own property. It's not going to affect any other properties around it, and as a matter of fact, those properties are already been split up by Michael O'Brien, who was here to represent, to help Rose in this petition. The board finds that the hardship suffered by the owner of the subject property, if the dimensional variance is not granted, amounts to more than a mere inconvenience, meaning that relief sought is minimal to a reasonable enjoyment of the permitted use to which the property is proposed to be devoted. And the purpose, obviously, is to place this ADU on close to where Rose lives, and so that her mother can enjoy the grandchildren and participate with her daughter for the reasonable enjoyment associated with this structure. And thus I move approval.
Motion is made by Mr. Rosen. Can I get a second? Second by Mr. Daniels. Any other discussion? Hearing none. Mr. Rosen?
Aye.
Mr. Daniels?
Aye.
Mr. Diamond?
Aye.
Ms. Hicks?
Aye.
Mr. Cagnetta? Aye. Motion passes. Good luck, guys. Yeah. Good to see you. All right. So, last on the agenda is the continuation of the petition of Cottrell Homestead LLC of 500 Waits Corner Road, West Kingston, Rhode Island, 02892, for an appeal of the zoning decision of the zoning enforcement officer under the zoning ordinance as follows. The applicant is seeking to appeal a notice of violation issued by the zoning enforcement officer dated July 5th, 2023, for premises located at 500 Waits Corner Road, South Kingstown, Assessors Map 14, Lot 65. The owner of the property is Cottrell Homestead LLC for the premises located at 500 Waits Corner Road, South Kingstown, Assessors Map 14, Lot 65, and is zoned OS. For this, we have the application signed and dated July 20th, 2023, which is the notice of the violation by the South Kingstown, by the town, dated July 5th, 2023. Continuation requests of August 10th, September 19th, August 18th, and November 15th until today. We have the supplemental applicants' materials, which are the photos 1 through 21, which will be able to show up on the screen. And then the Rhode Islander magazine, which is 14 pages. We have the 200-foot abutters list, legal notices, proof of certified mailings, and notarized affidavit of mailing. And then we have several correspondences. We have a total of 8, I believe, correspondences. Roy and Gail Richmond of 348 Waits Corner Road, which has 10 photos, as well as a planning board decision of 2009 and recorded in the land evidence book. The conservation plan of 3 pages from the U.S. Department of Agriculture, dated May 23rd, 1977. And then Glenn Chappell, Dr. Roger A. LeBrun, 361 Waits Corner Road, Dr. Charles and Judith Sampson of 592 Fairgrounds Road, Tanya McCarthy of 319 Waits Corner Road, Richard and Pat Collinson of 100 Acre Pond Road, Douglas Langdon of 937 Finnell Hollow Road, and then John King and Helen Murderer of 354 Fairgrounds Road. And did I want to read in all of those letters?
I wouldn't, because we'll be here all night. Otherwise, they're all part of the record. Just because I think it's been several years since the board had an appeal like this, I just want to set the stage legally for what your role is as you're hearing this. You're empowered to review decisions made by the zoning enforcement officer in the performance of his duties and issuing notices of violation. So you're legally empowered to review the decision, and you're legally empowered to essentially sit as a super zoning enforcement body, reviewing the decision, and specifically, you can reverse or affirm wholly or partly. You can modify any notice of violation. So you're essentially deciding, was it right or wrong to issue the notice of violation? Any further appeals, whether you grant the appeal or deny the appeal, if any aggrieved party wants to appeal that further, that goes to Superior Court. The Superior Court has the power to issue declaratory rulings. Your decision tonight on the appeal, if you make a decision tonight, you're not going to be issuing a declaratory judgment. You're just going to be either affirming or reversing the notice of violation. So you can consider all the evidence. To the extent that any of the arguments are going to touch on non-conforming use, I can provide you advice on how to deal with that at the conclusion of the evidence.
So is it a matter of us sort of understanding what the notice of violation was on what specific date?
Yeah.
Because, I'm sorry.
I think what you can do as far as procedure is you can ask the appellant to put on the case, right? The counsel for the property owner who received the notice of violation, and they can explain the argument. Then I think you should hear from the building official, right? Okay. And then it's a public hearing. There are people here. You've noted the correspondences. They're all part of the record. Yep. And anyone who's here tonight can weigh in as well.
So basically what we're doing is we're considering sort of this letter that was sent from Mr. Gorman on for an inspection on the property of July 3rd, 2023. Mm-hmm. So basically anything that's happened after that is irrelevant.
Is really not relevant, I would say, and okay. I don't know if we're going to be hearing anything about after that date, but we're focusing on when that notice of violation sent, was that the right call or the wrong call? So
if the appellant or not the appellant, is it the appellant?
Yep.
Okay. So if they sort of rectified the violation since then, they wouldn't be here.
Well,
right
you know,
now.
that kind of goes to enforcement, right?
Okay.
So.
And we're not here to judge that.
We're not really here to judge that. We're here to judge, was it proper to send that NOV on that date?
Okay, so was the letter and was the
Yeah.
observations, or was what was observed a violation of the zoning ordinance?
Correct.
And that's why we're here.
Yep.
Got it. Okay, great. So, come on up. Good evening. I don't think you are on. The one with the person with the head on it, I think. Yeah.
Now I see the red light. All right. Good evening, Mr. Chairman, members
Good
of the
evening.
Zoning Board. Attorney Stephen Surdit with offices at 585 Kingstown Avenue here in South Kingstown on behalf of the Cottrell Homestead and Farm. Thank you for the opportunity to be here tonight and make this presentation to you. I think your solicitor hit the nail on the head. This is an argument from our perspective, or a discussion about pre-existing legal non-conforming uses, also known as grandfathered uses. This is a unique property. As my clients will testify here this evening, this property has been in the family for many, many generations and has transitioned, but has remained a homestead and a farm. In fact, you'll see in here that they took great pains in 2009 when one of the lots, which is owned by one of the complainants and the public who are here this evening, to note that this property was a working farm and a working homestead at that time and continues to be so. I'll touch on some briefly. We have a expose editorial that was put together by the Providence Journal in a Rhode Islander insert, which I don't even think exists anymore, that documents not only in pictures and in words and in quotes from the family that this is not just a industrial working dairy farm. This is the center of their family life. This has been their cultural focus for generations, and they've used it as such. They've used it for family celebrations. They've used it for birthday parties. They've used it for Civil War reenactments where folks came and camped out. It has been used for countless different uses, and those are just some of what we can document. We have a unique, South Kingstown is unique in that it has this very deep agricultural history, as well as a very unique coastal history and coastline. And there are times when those have dovetailed together. But in this case, this is an old, historic family farm. My client will go into, they just had a 100th year anniversary of the family ownership of the farm. And during the course of that time, I'm going to hit the nail on the head. They have camped on this farm. They have camped on this farm for days, for weeks. They've never been paid for campers. They've never opened it to the public. They've never advertised it as a campground. Absolutely. But they have historically used it and camped on it in tents, in campers of different eras. And a reason I bring up the coastal uniqueness of South Kingstown is one, I believe, and this is me editorializing to some extent, one of the reasons that these coastal towns, Narragansett, South Kingstown, have these very harsh regulations regarding camping and the use of campers on existing properties is to protect residents, but typically to protect our coastline and the very tight dynamics that go on there, as well as to protect the ecology and environment of our coastline, where we don't want campers on postage stamp lots without OBWTSs. We don't want it to proliferate, and we want people to have to go through the process and build homes and pay taxes and do all those things. Mm-hmm. So circling back to, I just don't believe that on a very large acreage homestead with livestock animals, agricultural ponds, my client will go into what this pond was created for and when it was created, that the goal of this statute was to stop people from recreating in a way that they have done so for generations, if not greater than 100 years.
Well, the only thing I would ask our council is that you're talking about us to sort of make judgments as to if this is applicable based on its history, which isn't necessarily in our, we're looking at it very black or white. I mean, there really isn't much for us to consider when it comes to historical use.
It's tricky to advise you on this because the Superior Court has been somewhat, I don't want to say inconsistent, but there's competing messages, and I'm referencing specifically a Superior Court decision from December 21st that involved a similar issue. A notice of violation was issued and appealed, and the property owner made an argument about non-conforming use. And the Superior Court said, as it has in other cases, zoning boards aren't empowered to issue declaratory judgments. However, you are empowered to hear the appeal. So part of hearing the appeal, I think, involves taking some testimony and hearing the evidence about the current use of the property. The Superior Court said, and I'm quoting here from the decision, the zoning board can confirm that an existing use, structure, building, or lot either complies with or is legally non-conforming to the provisions of the applicable ordinance, but it may not provide information concerning proposed uses, structures, buildings, or other development. So I think what we're talking about here is how was the property used when the notice of violation was issued back in July, and was that, if it was issued properly, you can deny the appeal. If you find, after hearing all the evidence, that you're satisfied with the appellant's argument that the activity in question was pre-existing, legally non-conforming, I think you're empowered to grant the appeal and reverse the notice of violation. So we have to be careful that we're not making declaratory rulings, but I think you're looking at how the property was used when the violation was issued, and again saying, was it right or wrong to issue a notice of violation? So
and no disrespect to the applicant. I mean, I'm just really trying to understand, is it, if we have the ability to say that it was a permitted non-conforming, that allows then for them to perform the activity that was said to be a violation, right? So I'm just sort of making sure that we have the ability to judge that as a legal non-conforming.
You have the ability to make that determination as part of your determination on the appeal.
Okay. Does that make sense to everybody?
And by the way, will assist, as we normally do, in writing the decision, the board's decision. So whatever motion the board makes when it's done with hearing the appeal and it's ready to vote, I would suggest, motion to grant the appeal and direction to legal counsel to prepare a decision for our review. That way, if it goes to court, it's a decision that can be reviewed by a court, and it doesn't have to come back here for, a better decision.
Yeah, and I mean, it's also making sure that we're helping you guys just stay focused as to what we can do to sort of understand that the relationship to the property. And I think, because the only thing I was really questioning was how far do we need to go back to understand sort of the use of this property, and are we saying that, well, when the first white man walked across this property sort of story?
I think it's really pre-existing non-conforming refers to before whatever regulation is at play. So, and I'm not sure if anyone in this room has researched when that specific regulation was added to the zoning ordinance, but usually, and I think for practical purposes tonight, we can think about when zoning was adopted in the 60s at some point in South Kingstown. So you don't need to go back to, colonization, but you can certainly consider evidence going back a few decades. I think that's appropriate.
Okay, so it sounds like that what they've presented as sort of background information is going to be sort of helpful for what you're saying for us to consider.
I think it will be relevant, and you can make that determination when the evidence comes in.
Fair, that's fair. Okay, thank you.
Thank you for clarifying.
This is helping us. So please
no,
continue.
and I don't want to waste anyone's time tonight. We want to be as streamlined as we can and drive at the point. And so at any point in time, please also feel free to interrupt me or ask questions. That's the point of us being here is to get information across to you folks. And
Fantastic.
we're quasi-judicial. We're not fully judicial. So in that vein.
I appreciate that. Thank you.
So with that being said, I'm going to ask Ms. Julie Bouchard, and I'm sorry if I mispronounced your name properly. Broder.
Broder, so please spell your name and
Julie, Julie, Broder, Brodeur.
Ms. Broder, do you swear to tell the whole truth and nothing but the truth?
Yep.
Excellent. So please continue.
So, Ms. Broder, if you could tell us who you are and your history with the farm and the homestead, and then we'll take it from there.
Okay. I'm Julie Broder, and I was brought up at the Cottrell Homestead in West Kingston. I co-own the farm at 500 Waits Corner Road with two of my brothers. One's here, Matt, and the other one is Glenn. We were all raised in the same house, living with my grandparents downstairs, and we lived upstairs with our parents. While growing up as a kid, I remember our relatives that lived out of state coming in and spending time with my grandparents and their family. My grandmother and grandfather had 9 kids, so there was a lot of us. Aunt Marion and Uncle Harvey always came through with their camper. They spent the night at the farm many times. My brother Matt thought it was cool, and he spent a few nights in the camper with them on the farm. In addition, the cow classifiers and other cow families and vet people, I don't want to say the sperm collection, were always welcome to set up their camper as well, staying at the farm. And we're pretty tight, and we've lived through the years having lots of family functions at the pond since it was dug in the 70s. It was great for fishing, swimming, and just having a great time. It puts you out of touch in the real world, even if it's just for a few minutes. My brother Matt, he built a shack down there in the 1980s when he worked at Arnold Lumber. He and his buddies stayed down there during the pond during all seasons of the years. He remembers spending New Year's Eve at the pond with his buddies. Over the years, some of the kids broke into the shack, and the shack is no longer there. My husband and I purchased a camper in the 1990s. For our first trial run, we decided to camp at the pond. We invited my dad and my nephew down for breakfast. I made pancakes and served them on styrofoam plates, and the pancakes were so hot they went right through on the plates, and that's why I remember this story. My husband and I also had a 4-H woodworking club, which camped down at the pond at the end of our 4-H year. At that time, we didn't have a lot of campers, but we did have at least one. Our kids had a blast fishing and cooking over an open fire. Also, the SRI Dairy Club also camped out during the 1980s and 90s. Our family has owned the farm since 1900. In the year 2000, we had a big party down at the pond celebrating the 100th anniversary. No one was ever able to see the activity at the pond until 2018, when we no longer grew cow corn. When we sold the commercial dairy cow herd because we couldn't make a living dairy farming, we rented the fields out to turf, and so we could afford to keep the property. At the present time, our nieces and their family have been spending time camping down at the pond with a couple of family friends. Those families also worked at the farm while still milking cows and were considered family. We have rented a porta potty over the years for many special events, so no one catches poison ivy where we don't want it, and keep the area sanitary. We would like to keep our family traditions going. I have 2 grandchildren, and I would like to camp out for the first day of fishing season. And it would be nice if I know we could. We hope that we'll be able to continue our traditions of camping over and having overnight outings at the pond for many years to come. We would be willing to add a privacy fence or trees, or willing to have the property surveyed to make sure that all the lines are in the correct spot. Thank you for your consideration.
So, Ms. Spence, if you could pull up the Rhode Islander magazine article. Julie, you ready? recognize what's up on the screen?
Yeah, it's my father and my nephew.
Okay, and they're on the front page of the magazine insert? So I guess we move this as appellants, whatever it is, it's already part of the record, but then that's fine. And that's, you said your brother? And
No, my father.
Your father?
And my nephew.
And your nephew. And were they in one of the barns at that time? Okay. Do you remember when the reporter came down to do this article?
Yeah, he followed us around for a year.
A year?
And my father would say, suck in your gut, he's taking our picture.
If you could go to the next page. Do you recognize those folks?
That's my father and my niece, Sarah.
And what structure are they inside of there?
They're in the barn.
Okay. Is the barn still there? Okay. If we go to the next page.
It's a split one.
Okay. And that would be the other half of the...
Yep.
It's a newspaper magazine. Is that your father?
Yes, and my son.
Oh, okay. And they're out tilling collecting hay or something to that effect?
Yes.
Okay, scroll to the next page, please. Now, this looks a little bit more starting to become what we're talking about. Who's out there in a gathering? Do you see?
Well, that's my brother Matt, right there.
On the right-hand side?
Yeah.
Okay.
That's my mom in the chair.
Yeah.
My father's in the yellow shirt. My brother Gary, I think it's got his arm going like that. I think Matt's looking at us. That's my son with the little the shorts on.
And was it a common practice to have campouts, picnics, as what's depicted here on the farm?
Oh, yeah. That was probably lunch during haying.
Okay. If you could continue to scroll down, please.
Just loading the hay. I think that's...
So you're just doing normal farming activities out there in conjunction with other things. You could continue to scroll down. Now, that was when you had the dairy farm, right?
Yes.
And you unfortunately recently had to get rid of the dairy farm? Okay, and when you got rid of the dairy farm, were there trees cut down? What caused such a big change on the site?
It's mostly that there's no money in milking cows.
Correct, that's why you got rid of the cows, right? And when you did that, you talked about how the tree lines changed. So what happened?
Oh, no, I just said that we would make... Oh, the corn is gone. We don't grow commercial corn in that field right now. It's rented to turf.
And historically, this field was the one adjacent to the lots that were created in '09, where the Richmonds live?
Yes.
We gotta keep, she's testifying. Nobody from the Piallery is testifying, please. Or Ms. Goins is gonna get mad at me. So that's what you see here is when you had the dairy farm, correct?
Yes.
And you had corn and other more traditional farm crops, correct? Just to keep up with the cows and
Yes.
feed them? If you could scroll to the next page, please. Okay. Do you recognize those gentlemen?
Yes, that's two of my brothers and John McGowan.
Okay, and now if you could scroll to the next page. All right.
That's my brother Glenn.
If you could scroll down just about halfway down the page. Now, who is June Cottrell?
My mother.
Cottrell, okay. And she's mentioned in the text on this page, correct? Okay. It's the third paragraph from the bottom, starting with
On warm nights.
on warm nights. If you could just read that out loud for us.
On warm nights, the family goes to the pond on the property where they fish and barbecue. Gary and his wife bring their camper. Julie and her husband come too. When the lights go down, says June, it is very peaceful.
Do you remember camping out there
Oh, yeah.
with June?
Oh, yeah, she was at every party.
And they would bring the camper down there? And people would sleep in it? And that's what this reporter put in her article, or his article, correct?
Yes.
And and that reporter followed you and your family around for a whole year.
Yes.
And this article was, to the best of your knowledge, published in 1993, correct?
Correct.
So you and your family were continuing this tradition that had started who knows when previously? Do you remember the first time that you camped there?
No. Not
What's
exactly
the first memory you have of camping on the farm?
I don't know if I remember. I know the one that I definitely did when our first trial run with the camper. That was because they said they didn't want to eat the pancakes because they felt.
But you remember camping there as a little kid?
Oh, well, yes. The pond was built in the 70s.
So let's talk about that. The pond was built, do you remember what year in the 70s?
It was built at the same time as the Richmonds was.
Okay.
They did them together.
So how did this pond come to be built, and who built it?
DEM built it.
Okay. And who gave DEM permission to build it?
My father.
Okay. Why did DEM, how did it come to pass that DEM wanted to build a farm on your property? Because most of us who deal with DEM now, that doesn't seem like an activity.
I think it was
DEM
to
would
keep
be
the
involved
water, the Chickasha, because it's attached to the Chickasha River. I'm not exactly sure on the details. But I think it was to keep the flow and the water clear and everything going, because it attaches in there. And
But you had been, to the best of your knowledge, the family had been camping down there even before
they could
the
have been,
pond
yeah.
was created.
But most of it happened after the pond was
And
built.
when the pond was created, everybody flocked to it now, right?
Yeah,
'Cause
that
you
was
could
the gathering point.
Okay. Could you swim in it now much better than you could previously?
Oh, yeah, yes.
It was now nice and deep and clean and clear. Now, and we have a couple of photos, I'm not sure exactly where they are. In 2007, you folks had an event on the farm, correct?
Mm-hmm.
What was that event?
2007.
2007 had to do with Abraham Lincoln.
Oh, you mean that's more Jessica.
Okay.
I'm not a Civil War reenactor. That's Jessica.
Are there any questions the board members have for Ms. Bouchard? Oh, I'm sorry.
Broder.
Mr. Broder, any questions, board members? Yep. Nothing yet.
Oh, one more, I'm sorry. No, you were at the meeting in 2009 when the Richmonds lot was created, correct?
Correct.
Okay. And in that decision, there's a notation that it's made clear, and I'm going to quote it, that the subdivision parcels are adjacent to the Cottrell Homestead and Farm, a working dairy farm recognized as an important historic and agricultural resource within South Kingstown. Were you at that meeting?
Yes.
What was the purpose from your recollection, of that clause being put in?
Because if the wind blows the right way, they smell our manure pit. Okay. Everybody smells the manure pit in the neighborhood, but it's in direct line.
And all the other activities associated with the farmstead, right?
Mm-hmm.
Tractors.
Yes.
Roosters.
Yes. Turkeys. Cows.
Camping.
Yes.
Events.
Yes.
So it was clear, and it was made clear back in 2009, that you guys were going to continue your activities as you always had for the last 109 years at that point?
Yes.
Okay. Sorry for making you come back.
That's all right.
Come on up, Miss Jessica. So tell us, if you could swear in, please.
Yep,
Sure.
so just state and spell your name, please.
Jessica Mayhew, and it's spelled Jessica. My last name is Mayhew, Mayhew.
Okay, and you swear to tell the whole truth and nothing but the truth?
Absolutely.
All right, go for it.
So if you could pull up some of that list of photographs, we're going to go through some of them.
Sure.
All right, let's start with, that one. To the best of your knowledge, who are those folks?
That's my dad and my big brother at the pond circa 1993. I'm not featured in this as much because I'm just a baby. I'm mentioned, and there's Christmas pictures if you go through where you see me in a really cute Christmas dress, but because I'm just a baby, there's not much of action shots. Kind of looking back, I wish I was a little bit older, but no, that's my dad and my older brother.
Okay. You can scroll down to the next one. And these are some photographs of other campers in and around your property, correct?
Yes, they are.
So you can scroll down through these.
And when are these photographs from?
Going around town and near the farm.
No, when?
When? Oh.
Whoa.
The weekend after yeah, the weekend after we got this, we've started digging into how we can basically.
So this was in July?
Yes.
Those pictures?
That's
Okay.
why it's all pretty in green. These were all taken in July.
Okay.
What's that? Oh, that's another photograph from the Rhode Islander magazine, and that's
Yep.
folks recreating on the farm, right?
Yep, that's my Uncle Matt who's behind me, and my older brother who's on the bike that Uncle Matt's holding, and then my cousin Peter is in there. And that's actually the very first tree in the background that I hit when I was learning to drive. Nice. And it's still a joke today that, because that tree is still standing, that's the very first thing I hit.
We could keep scrolling down. More recreations on the farm.
Making s'mores, because that's still, we camp there with my 5 and 7-year-old, and their very favorite thing to do, even now, is they'll go to the edge of the woods and they all need to grab their own s'more stick. No one can share. Everyone needs their own, and we go through tons of marshmallows and they have a grand old time.
Is that something you remember doing as a kid?
Yes, because my birthday is actually April 8th, so depending on when the calendar falls, it's opening weekend of trout season, and for the longest time, my birthday meant opening weekend of camping.
And you would camp in tents and campers?
Yes, I remember as a kid seeing my uncle's shack and not going in it because it was creepy, but we always had a pop-up camper, and sometimes it would be really hot, sometimes it would be really cold, but we always had fun. This was pre-technology, this was the late 90s when things were pretty happy.
We did continue to scroll down, please. More s'more making?
Nope, that's a chicken barbecue. We actually, my dad and my uncle, they would do, and we still actually cook like this. We still have those grates. It's a great way to do a party down there because you can do a lot of corn, a lot of chicken halves. With chicken, obviously, we raised because.
And is that the pond over there on the corner of the property? So again, this
Yep.
all occurs down in that area where you would traditionally recreate and
Yep.
traditionally
Mm-hmm.
camp and all kinds of recreational homesteading activities, correct?
Is
Yes.
that your uncle's shack in
Yes,
the back?
that is the creepy shack.
Yep.
Well, it wasn't so bad then, but as the 90s wore on, before it got knocked down, it kind of got creepy. But yes, that's the shack.
Yep.
If you continue to scroll down. Do you recall any of the folks in this photograph, or do they all predecease you?
So the only one who I can definitely identify in this picture would be, she's my great-grandmother, but she was called Granny, and she was the lady in blue in the corner. So this picture we weren't sure was at the farm, but we've later identified it as the corn crib, which would be over by the house. But big family gatherings has always been part of our family. Granny died, I think they said in 1981, so this would have been in the 70s is my best guess, but I always know her face just from the pictures I've seen.
And at those family gatherings, was it common for folks to stay over and bring campers, as it was, folks in your family have always had campers?
Yes, I can remember very, very vividly the 100th anniversary party when I wasn't even 10 years old. The field was full. We had campers and we had tents because it was it was a 100th anniversary for our family owning the farm, but my grandfather, he bred cattle and he sold cattle across the United States and into Canada. And everyone, even to this day, you say our last name and people know who we are. So everyone who was in the dairy industry, as well as family, was at the 100th anniversary party.
Continue to scroll down. Nice family gathering photo.
Yes. I will do my best to identify as many as you want. I was going to say...
Say it called them Cottrells, and that's corn behind them there, right?
Yes. So corn was always a big feature down there. No one ever knew. Like when I was a teenager, after I graduated high school, we'd have parties down there, and parents were fine with it because we weren't going to leave, and no one knew we were down. No one really knew we were down there because you couldn't really see. It was very private, and the corn made it so quiet.
Continue to scroll down. This lower photograph here. Do you recognize that one?
I do. That's 2007 when we had the Civil War encampment at the pond. And one of the reenactors is a professional photographer, and he wanted to do some fun shots that weekend.
And And these are some folks down by the pond?
Mm-hmm.
Can you scroll down to the next one, please? And what are those?
Those are A-frame Civil War tents. They are 9 feet tall, roughly. The tallest one's about 9 feet. The shorter ones are about 7, and they are between 7 and 9 feet long.
And they were up all weekend?
They went up on Friday, and they didn't come down till probably Sunday afternoon. Yeah.
And did folks sleep underneath them?
I have spent many a night under those camping.
So, and again, another family gathering that occurred on the farm in the back corner near the pond.
Oh yeah, and it wasn't just our family. This was for the 3rd Arkansas Company A, 3rd Regiment, 3rd Battalion of the Army of Northern Virginia. So it was an entire encampment. It was a training weekend because when I was younger, my family would do Civil War reenacting. So because we had the space and the fields, at the time their corn wasn't up yet, they were using the fields to drill in. So there was literally 50 guys in Civil War uniforms marching around the fields with tents to boot. So
they were all camping and staying on the farm?
Yes.
Can you scroll down a little bit? Is this another photograph of...
From that weekend, and you can see the porta potty and you can see the creepy shack.
So it was normal to have events there, including porta potties?
Yes.
Outdoor cooking, and you can see a tent, another
Yep.
sleeping arrangement there as well, correct?
Yes, you can, because some of the people came, but they weren't staying in Civil War tents because they are bulky to pack. So some people came and slept in regular tents, not just Civil War tents.
You can scroll down. More of the Civil War tents, correct?
Yes, those are more of the artistic shots that the photographer was getting for his website, but pretty shot on the farm.
You can continue to scroll down some more artistic shots of the farm.
Yes.
Whose truck is that?
That would be our friend Alan Stone's truck. We were cleaning up after a camping weekend. That is my son Abram and one of his 4-H friends, Piper.
So you continue this tradition to today with your children?
Absolutely. My kids absolutely love getting to go down to the pond. They love getting to go to the farm. It's part of, I'm the 5th generation and my kids are the 6th. So it's part of who we are at this point.
And it's something that you would like to be able to continue these traditions, right?
Absolutely. I don't know what we would do without them.
And you guys camp out, and that's your camper and more children.
More children.
2002?
2022, that was recent.
Oh, sorry, 2022. I forgot about the 20s.
Yep.
So it's your position that you've camped down there for as long as you can remember?
I can't remember I don't honestly remember a part of my childhood where spring didn't mean camping on the pond or at the pond. I'm 32 and we've always been down there.
Is it fair to say that the change in the conditions of the lack of corn and the transition to turf farm changed this area of the farm considerably?
We don't have the corn as the noise buffer, but we've made changes to our camping style. We have bedtimes for the children, naturally, because my kids are the youngest. They're 5 and 7. The kids have bedtimes. We keep it quiet now because, like I said, we do not have the corn as a buffer. And
it's your intent and it's your goal to ask this board to recognize that your family has historically camped, slept in recreational vehicles and tents on the property, correct?
Yes, because I'm not ready as a parent to have that talk of disappointment with my children because all they know is that we had to stop and they don't know why. And from the adult perspective, we told them that we were going to do what we could so we could continue it. But when we had to stop in July, the kids asked why. And how do you explain this to a 5-year-old? You can't. I don't have the ability as a parent to explain this kind of setting to my kids. But I told them mommy was going to do what mommy could. So
now we've had some discussions about the fact that you would consider putting in buffering, you would consider putting in a tree line, you would consider a discussion with the neighbors to that effect, correct?
Yes, of course, because we want to be able to continue to use it. All the kids miss it. It's our spot. I mean, I had my son's end of preschool party down there, and so many parents were like, this is amazing. None of the kids want to be on a tablet, because the dads had built a dock. We have a little paddle boat for them that with life jackets, they can catch their first fish. There's a picture somewhere through here where you see my son at 4 with my husband, almost the same exact spot as you see in that picture with my older brother and my dad catching his first fish, and that light in his eyes and his big smile, because they know that they're going to catch a fish there. And those are memories that kids aren't getting these days because they're attached to their screens.
And those memories you don't believe can be created without the ability to recreate out there and to stay overnight, correct? And
correct.
In a camper, in a pop-up tent, in
right.
a tent.
Right, because we are so fortunate that we always had this, and that it's suddenly taken away. It's disheartening for us, because it is to take the kids to a campground. It's an expense. It's an added expense that we don't necessarily have, and we've always been very fortunate to have the fresh, clear water at the pond. It's a nice sand bottom. The kids have all learned to swim in it. They are creating these core childhood memories.
And this isn't something that you and your family do every weekend, right?
No. So we start camping typically in May, and we might do a weekend here to May, June, but we show cattle, and we show rabbits, and we show poultry, and these kids show from the end of June through July, through August, and we do a couple fairs in September. So if there's an odd weekend that we're not at a cattle show, we do try to go camping, but we need the campers at the cattle shows. And
so you're culturally and historically, you're not suggesting that you have camped there every day, every weekend, or for an entire summer, correct?
Correct. Our lifestyle, like I said, going to cattle shows, it doesn't align for us to camp all summer.
And even more so, historically, that's not what was done, right? It was occasional camping as a recreational activity, not as a monetary activity.
Correct, because like I said, I'm 5th generation on the farm. I was raised going to fairs and showing cattle, and to me it's one of the greatest things ever is to watch my son. He loves getting to show cattle, just like mom, just like grandpa, just like his great-grandfather. So we're very blessed in that sense.
Do you remember other folks who had cattle coming and camping on the farm as a kid?
Yes, I do, actually. I do, because it was fun. Because, again, when we were doing this was pre-cell phones. When I was a kid, it would be pre-cell phones, and pre-internet. So when we would have campouts at the pond with our friends who had cows, it was fun, wholesome childhood fun, because you never got to see these people all the time. So when we would have these events, it was even more fun and more special, because they were few. Well, they weren't few, but they weren't every weekend.
And fair to say one of the reasons there aren't as many photographs and videos is because no one had a cell phone.
No.
And that wasn't anyone's goal, was to document it.
No, whereas now I could go through, if I could hook up my phone, you would see probably hundreds of photos. Because I take pictures of my kids down there, and I even post pictures of sunsets on the farm to our town, South Kingstown page, and people love to see the pictures of family time on the farm, because it brings people back to a really happy place for a lot of people when they see the pictures that I post from the farm.
Is there any, I think we've covered your history and your personal relationship with camping on the farm. We did have one additional person who unfortunately was sick and unable to attend this evening. She did draft a letter. Do you want to go through that letter, and why don't you identify who drafted it?
Yes, absolutely. So this letter came from my cousin Pam, except for when you hear me say cousin, you're probably thinking of the person who's in their 20s, maybe 30s. She is not. She's actually my dad's first cousin, and she has a farm on Ministerial, and she has Ashier cattle, but she grew up on the farm in West Kingston as well. So
And she is, so she's your cousin, correct?
She is my cousin, yes. She's just significantly older. Like I said, my grandfather was one of 9 children, so there is some pretty large age gaps when we would get to these family events, and it just meant that many more people, which was nice. All right.
Why don't you give us a quick read of this?
Sure. It says, hello, I'm very sorry this is so late. We have been ill at my house, so we're going to just... I am one of the older cousins of the Cottrell family. I lived next door, but spent most of my time at the farm with my grandparents, uncles, and later their families. I remember very well camping as a little girl at the pond. We had 2 other ponds on the property. They were not fenced off from the cows, and later not accessible. There were always family gatherings there, and because the original Cottrell family had 9 children, some traveled a distance to attend functions. People camped at the pond, and my aunt and uncle from New York even brought a calliope to play music. They had a big motorhome and traveled a great deal for their museum and were featured at the local fair. Throughout the years, there have been openings for fishing day campovers, weddings, receptions, Civil War reenactments, graduation parties, and often a family would stay in the tranquil area of the pond visiting and catching up around the fire. My grandparents, aunts, uncles, etc. were not into alcohol or any spirits. They were simple farmers, and when the opportunity to have the pond cleaned out, they were thrilled. It made for a cleaner, nicer area, and the children at the time even put up a little sleeping shed. This would have been in the 70s. My husband and I took our motor home there with our children a few times each summer and thoroughly enjoyed it. My 25th high school class reunion was at the Richmond's home across the fence. I parked our tent camper near the pond, took a cow to the party for a few minutes, as I was always teased about showing cattle, and at the end of the night, slept in my tent camper. Since then, the great-grandchildren, their friends, and family have enjoyed the spot. They have a little boat, and the kids just love it down there. I understand that the group has grown. I also understand, however, that the pond is not used as much now that the kids are involved with showing at different fairs and the regional competitions. This land, this farm, this family, and this tradition is very special to all of us. It is not on the road, and when this all started, there was no house on the other side of the fence. They know the pond was there, and they knew the family gathered there. There is so much more I can tell you, and I hope this helps. Pamela J. Jeffrey.
And I have copies if the board wants physical copies, and ask that it be included in the record. I would, at this point, allow Mr. Gorman to do his presentation and reserve the right to respond after he and the public speaks.
Absolutely. Thank you. Wait, before, is there any questions by
sorry,
board
I didn't
members?
offer,
Yep.
Ms. Petrella or myself.
Thank you, Mr. Chairman. Have you ever rented space for campers outside of your family on this property?
No, we don't want people who aren't family there, family or friends. So if we have a party, then we open it up. Say if you're invited to a family party, you are more than welcome to camp, but it's never been open to just the public. If you were to call and say, I want to rent a spot down there, you would be told absolutely not.
Okay. You testified that you had a Civil War enactment situation there. Did you charge for that? Somebody pay for that?
Nope, because my dad at the time was captain of the unit. Basically, as part of being an official reenactment unit, they have to have so many training weekends. And they can happen when you're at a reenactment, like actually at an event down in Virginia or wherever, or you can just happen to get together and do that. So basically the reenactors decided they wanted to do it at the farm, and we said, okay, because it checked off the box, but no one paid. It checked off the box for them to get their training in, but no one paid. They didn't pay to go down there. It was
Okay. In your recollection for the years that you've been associated with and lived on the homestead, what's the most number of campers at one time would you say, if you can remember?
Sure. So typically, the most would honestly be in the last recent years, and that would be my sister. Our family friend, Paul Maynard and his family. Paul used to milk cows for my grandpa. Bryn Bradley and her family, her ex-husband Raymond, also milked cows for my grandpa. And then we have one of our other friends, Rachel Jordan, and her family. Her dad was friends with my dad. He grew up down the road from the farm, back in the 70s and 80s. So her dad spent time there as a kid.
So how many campers in total? 4?
4 or 5, maybe?
At one time?
Yes, because that's typically what we would see is 4 or 5 in a weekend, and then tents too, but, not that many.
Okay, nothing further at this,
Okay, thank you, Mr. Daniels. Thank you. Board
Thank
members,
you.
any other questions for the applicant or the witness? Nope.
Thank you,
Okay.
Mr. Chairman.
Thank you as well. So I just have a question of somewhat of a, and I don't know if this will kind of come up eventually, but I mean, if there is a traditional, sort of activities that what limits it at that point? Like how do you put boundaries on something that was traditionally?
The idea behind the law about pre-existing legal non-conforming uses is, the idea is, if something was legal before zoning regulation is adopted that makes it illegal, right? That pre-existing legal non-conforming use can continue in existence. That's state law. It can't expand unless it receives whatever relief is allowed, and some towns don't allow legal non-conforming uses to expand at all. We do with appropriate relief. We have a provision allowing expansion of a non-conforming use by a special use permit. But think of a non-conforming use as frozen in time. That non-conforming use is allowed to continue in existence under the parameters or at the same scope and scale as it existed when it became non-conforming.
So they can't have like a Woodstock there just because they had other gatherings. They can't all of a sudden say we're going to have a huge event just because we did.
It's easier, I think, for a board to, a non-conforming use is sometimes more difficult to define and put parameters on than a non-conforming structure, right?
I think it's that mic that's making it do that. Sorry.
Thank you. So I think when you, at the conclusion of all the evidence, right, once you've heard from the neighbors, you can, I think, consider the parameters of what's being described compared to, and you'll hear from the building official, what he observed when the NOV was issued.
Okay.
Right.
That makes sense. Okay. Mr. Gorman?
you need to swear to building official?
Others have? No,
I
I'm kidding.
think
That's
you
horrible.
can in this case.
And you are?
James Gorman, Gorman.
And you swear to tell the whole truth and nothing but the truth?
I do.
Excellent. So please go ahead.
Thank you, Mr. Chairman. Just to go over the background and as well as the violation section and history of the ordinance. In brief, on or about June 30th, 2023, the building department received a complaint related to 500 Waits Corner Road. The nature of the complaint was that multiple individuals were camping in tents and recreational vehicles located on the premises near the southeast property line. It was alleged that the RVs and tents began appearing seasonally each summer since 2020. On July 3rd, 2023, I inspected the subject property from the abutting property located at 348 Waits Corner Road. At that time, I witnessed 3 recreational vehicles located on site. I want to bring these up because I don't think they were included. Maybe not. There was also a portable generator being utilized in a nearby portable toilet. The following July 6th, a notice of violation was prepared and mailed to the owner and registered agent. With regard to the violation section, history of the ordinance, this provision referenced 503.6, parking and storage of major recreation equipment in a residence district. This section can be found in the 1976 zoning ordinance, although at that time it was referred to as Section 310. It's my understanding the purpose of the ordinance is to prohibit the use of campers, like Attorney Surdet said, in tents for habitation outside an approved campground due to the concerns relative to sanitation, noise, and safety. Based on the initial appeal application and the appellant claims of pre-existing non-conforming or grandfathered use, so to speak, it should be noted that the area in question was densely vegetated in 1972. This is based on aerial photographs, which can be seen on the Division of Statewide Planning website, which I'll pull up shortly. In review of all these historical photographs taken since 1972, only during the fall of 2020 was an RV pictured at this area in question. What I'm going to do now is pull up these, which I will also include as part of the record. So what you're seeing here is the pond in 1972. However, this is on the Richmond's property. This is the aerial photograph from 1981. This is the pond in question. So in 1972, this area here, densely vegetated. Fast forward to 1988. (1997). 2003, 2004. This is 2008, 11, 14, 18, 19, spring 2020, fall 2020. That's the camper in question. In closing, I believe this appeal should not be granted. I mean, many of the arguments made tonight are that this is a non-conforming use. However, most of the photographs and events that they're describing are accessory to any residential property, which would be allowed, such as a birthday or graduation party or a barbecue for a family member. I don't have the photos of that were attached with the notice of violation, but they're specific to the camping and recreational vehicles in this area of the property. This is not for one night only. This is for multiple nights, many nights, use of generators as well as portable toilet. So for habitation, which is the problem.
So, Mr. Gorman, and so you take into consideration sort of the context of historic usage, and not only by record, but also by sort of discussing it with both the complainant as well as the property owner? I mean, is it something that you kind of dig in fairly deep, or is it more of what you see is the violation and that's that?
Well, the initial application was filed in July, the appeal, which stated on its face that it was appealing my decision based on it was a legal non-conforming use.
Okay, and so is it that you're saying that they could have, by right of just any of us using our property, we can have people sort of stay outside on
by people, family, and friends. There's nothing to keep you from having a graduation party or a wedding on your property for a family member.
Right.
These are accessory events to a residential single-family dwelling.
Okay.
The town or the ordinance could restrict that from, you to conduct that type of activity. And many of these are, the photos and the descriptions are just that, it appears.
Right. So when they cross the line is when the vehicle is there, but nobody's using it? Or is it...
somebody's sleeping there, somebody's using it for night after night. This isn't, in my opinion, setting up a tent in your backyard for your niece or your grandchild. This is somebody running a generator, living in a camper for multiple days on end, weeks on end. That's the nature of the complaint.
Okay.
I just want to interject, and Jamie, I just emailed you the notice of violation that has the pictures you took back in July, so while you're pulling that up, I just want to remind the zoning board, because now this issue is coming up, what is an accessory use? And here we're hearing from the appellant, they're appealing the notice of violation based on the fact that the activity in question is considered pre-existing legal non-conforming. I think one of the things that you can consider is this a permitted accessory use, right? Because the town allows accessory uses, right? And that's a use that is customarily incidental and subordinate to the principal use of the property. So I think, and you can clarify from the building official, the violation was issued because in his determination, the activity exceeded any kind of permitted accessory use. So assuming you agree, if you agree, then the question would be, was he still right in issuing the NOV because it either, or was he wrong because it was or wasn't a legal non-conforming use? Well, and that was going to be my next question in terms of what they were also talking about was use of these vehicles for their primary use, which was as the farm use, that they're going from show to show and they're staying sort of there, so they might need more than one recreational vehicle that is parked at the site. So, I mean, so at what extent does that crossover happen? It's like, okay, well, you're using these for an accessory use that is, for the activities on the farm, but then you're kind of sleeping in it to have some fun too. Like, and so where is that line drawn that your vehicle's there for the property's use, but now you're using it for something different? And that's for you to determine. Right. There are no easy standards or bright lines for an appeal like this. It's basically you're considering all the evidence and making a decision at the end. Okay, so I will open it up to others then. To ask Ms. Hicks, please.
I have a question, Mr. Gorman. So you said you received a complaint and you went out to look at the situation. What was the basis of the complaint? Was it somebody simply watching the property and going, oh, those campers have been there a long time? Was it a noise violation? Was it people, I don't know, running around? What caused the complaint?
It was a combination. So the nature of the complaint was essentially that noise, the campers have been there for weeks already, and that it's I believe the third year in a row that this has occurred at the same time of year, and that it's, whether it be the straw that broke the camel's back, but it was, noise generators through the night, and this is not like a one night, this is weeks on end, so you can understand that this isn't it didn't sound like a one-day barbecue for a family event, but that was the complaint initially.
So in somebody sitting in their backyard, I mean, and created the disturbance, if there wasn't a vehicle there, then they're allowed to sit there.
Well, we do have an unruly gatherings ordinance.
Fair, but that wasn't the violation. I mean, the violation was the fact that these vehicles are there.
People are sleeping in them, staying in them overnight.
Right.
Correct.
Okay. So it was the combination of the vehicle and the gathering that made it the issue, that they were gathering in the vehicles.
Yeah, and there were other photos that were in the appellant's list of photos showing other properties with campers.
Right.
I mean, that's something that's a complaint-driven basis, how we follow up on it. It's in many properties, you can't see these from the road, so in this case, we received a complaint and we responded, and this was the action we took.
Okay.
And if you could scroll back to the first page of the NOV, I think we can kind of narrow what this is about. If you notice, the notice of violation quotes a portion of section 503.6. There are a few different prohibitions listed in that section, but if you notice, the existing condition that was specified as there are 3 campers located on the premises which are being utilized for sleeping purposes. And the correction that's indicated is cease the use and occupancy of the campers immediately. 1 camper may be stored on the premises provided it complies with the above noted provision. So that's what we're looking at here.
So it was being utilized for sleeping purposes. So, but I think if there were just 3 vehicles there, that they would be a different argument. It would be then that you just have too many vehicles there, but that they aren't. No?
Recreational vehicles?
Yeah.
So they'd be allowed to store one recreational vehicle.
By the ordinance, not necessarily
Correct.
by their historic, but by the previous use, because that argument could be made that, listen, we've had more than 1 vehicle here since the 70s.
It hasn't been in that spot since the 70s. So,
okay.
They're making that argument tonight, but I wasn't aware of any argument at the time.
Okay.
When I drafted this,
Yep.
certainly.
Okay. Mr. Daniels.
Thank you, Mr. Chairman. Just a clarification, your violation was issued based on residential district. However, in the agenda, it indicates that the property is zoned OS. Could you define what OS is? Because I'm not familiar with that.
So this is open space. So this lot is surrounded by residential, I believe, R80 zoning district. I believe the development rights, they can correct me if I'm wrong, this is deed restricted farmland, so the development rights are sold, and I think this is permitted through DEM as well. So there's restrictions on what can be conducted on the property. Primarily it's agricultural in nature. But for the purposes of having a dwelling on an open space, that's not allowed except in the Section 301 allows that in conjunction with a farm. And it also points to accessory use requirements, which is the citation in the notice of violation that is accessory use to the principal use, which is a farm. Sorry, that sounds confusing.
And I'm just looking at the GIS now, and maybe if you could pull the GIS map, I think this will be helpful. I think it's a split zone lot. Most of it is zoned open space, but there's a portion of the lot that is zoned residential. So it is open space, a portion of it is residential. So that was a slight mistake or omission in the agenda. I don't think it affects anything. I think we're still here looking at the notice of violation.
So it's fair to make the conclusion then that this is a residential zone, because that's what the violation goes to. It goes to a residential zone.
I was waiting to see that, and Jamie, I don't know if you can, is there a way to decrease the transparency of the zoning layer so you can see the aerial behind it? There may not be a way to do that, but okay, yes, that's exactly what I was, okay, so looking at this, that northern portion, that little carve out of the lot, that's the R200 zone, correct? Correct. Okay, and the rest of it that's colored green, that's the OS open space. Jamie, can you mouse over for the zoning board where these campers are located? Where was the one that that you based your notice of violation on?
This area right here where the cursor is circling.
So that's defined as open space. It's not defined as residential. Am I correct in that determination?
Correct. This is one lot, one parcel.
Okay.
Split zoned.
All right. Let me ask you this then. You personally observed 3 campers. Is that correct?
Correct.
Not one of your associates, but you?
Myself.
Okay. How did you determine that they were being used for sleeping purposes? Did you look inside? Did you see somebody sleeping? How did you make that determination?
So based on the photos with the bump outs extended, I did not go there at night. I did not look in the windows. But based on the bump outs extended, the generators running, and as well as neighbors, multiple neighbors who advised me that that's what they were witnessing.
So irregardless of that, the fact is that there were 3, and one is allowed, in your determination, one is allowed in a residential district, but not for sleeping purposes, for storage purposes only. Am I correct?
That's correct.
Okay. Are you aware of any previous violations that were issued on this property for any reasons?
I am not, no.
Okay, thank you. That's all I have for now. Thank you.
And based on the attorney talked about an easement? No, not an easement, but there was something attached to when the building either rights were sold or otherwise, to say that there are certain things to kind of be expected to happen on this site, right? Smells, things like that, nuisances that are related to the activities on this property, right? So within that, you can have common things that are nuisances that could be associated with a farm, be it chickens, cows making noises, smells, things like that.
There's the Right to Farm Act, which we don't have to get in. I'm advising you tonight, we don't have to get into the Right to Farm Act for purposes of this appeal. I will say that the use regulations table, right, and there's 2 tables in the ordinance, you can review it. The open space zone, right, is intended for open space. Residential uses typically is not permitted, except the table specifically notes farm residence permitted as accessory use in OS zone. So I know we're not done here because we haven't heard from the neighbors yet, but back at the outset of the hearing a little over an hour ago, I mentioned that you, as the board, you're reviewing the building official's determination. You can affirm the decision, reverse it, modify it. You don't, I think, have to find that the notice of violation was issued. In other words, you can deny the appeal even if you find that it should have been issued under a different section of the ordinance. Okay. So I think it's something for you to consider, the zoning of the property, right? Right. But in other words, the fact that it was noted as being in a residential zone, and now I think we're clear on part of, only a small portion of the property is in fact in a residential zone, I think you can still, at the end of the day or the end of the night, consider all the evidence and determine whether the NOV was properly issued.
Sure. I mean, the only reason I was asking that is just to you know, if let's say the neighbors had complaints about other things related to the farm, and if we can associate this as part of the farm or not, and I think that's.
Yeah, I think you can make a line, and obviously for a property like this and with a family like this, and not really even commenting on any person or persons, just, you know, a farm, a family that lives and works on a farm, there's going to be blending, right, of the residential and agricultural, but I think you can take notice of that notation in the zoning ordinance that a farm residence is permitted as an accessory use.
It's permitted as an accessory use. So not its primary use, but you can use it for residence every once in a while.
Yeah, and thinking back to the GIS map, that aerial, right? Most of this property is zoned open space. There's a carve-out of the property, right? And I haven't reviewed the document of transferring development rights, but it seems, and someone can correct me if I'm wrong, most of this property is set aside, is restricted for agricultural purposes. A portion of it is permitted for accessory residential use.
Okay. Questions, board members? Yes.
Was, from the testimony we heard, was it represented that these campers in question would arrive on Friday and depart on Sunday, or did I misunderstand that? Was that just some of the structures?
The testimony of the appellant? So, I mean, from what I heard, there was not a schedule of when they would arrive or when they would go or how often this would happen. It was just over the years, and from what they said, it was many years, but a lot of the photos were of people at a cookout or snapshots. Some weren't dated, but there was no frequency or schedule that I could determine.
But the complaint that was filed was that these campers in question were there for weeks.
Correct.
Okay, thank you.
Anyone else? Mr. Diamond? We're getting there. Okay, excellent. So, is there someone who wants to speak in support or opposition to this? Come on up. And please just state and spell your name, please.
Hi, Roy Richmond, ROYRICHMOND.
All right. And you swear to tell the whole truth and nothing but the truth?
I do.
Go ahead, Mr. Richmond. How can we?
Like I said, none of this camper crap went on until 2020.
Okay.
And we've lived there since the 70s. Our pond was there before their pond. Their pond was actually dug by DEM because they said they was going to irrigate out of it, and they never did irrigate out of it. That's why the pond is there.
Okay.
And as far as the buffer, they're talking about putting a buffer in. I already did that. I put in a fence. I put in like 30 Japanese willows. It doesn't make a difference.
Okay.
There's been as many as 6 campers, 7 campers there easily. And they come at like 3 o'clock in the afternoon. They start up generators for all these campers, and they run all night long to cool them down because it's obviously hot in the summer.
Sure.
And as far as when they come in, they go to the Washington County Fair. They're all into the Washington County Fair, is what it is. And then after the fair, they come back and they stay there all summer. They don't go out of there until the snow flies.
Okay. And
we can't even go out in the yard and sit.
You said it's about 6 campers or so, and it could be more or less.
There's some more, so yeah. 4th of July is a big...
Yep. And you guys had submitted not only some letters, but also photographs as well?
Yes.
Okay. And how long have you lived there? How long have you guys been living there?
Yeah, mid-70s.
Mid-70s?
Yeah. Our pond was there actually before the Cottrells. Ours was there. We got a permit to clean it out, dig it out further. And then Oliver, which was a great guy, their dad, and he see us digging it out, and then we had a crane with a drag line in there. And he went to the DEM. The DEM gave him a permit, and they just walked it across the property and did his.
Mm-hmm.
But there was probably since the 70s right up to 2020, there's probably, you can count on one hand how many parties have been there. If you look at the pictures, it's the same ones over and over and over.
Right. So you're saying these aren't sort of limited to just a few nights a summer?
No. This is after the fair. They're there for the summer.
Okay.
And I mean, we can't even go out and, we've had friends over we have go back in the house. They're yelling, screaming. The dogs, they got dogs barking. They're yelling at the kids. And one thing that upsets me is they come and they have a 22s. They shoot down by the flagpole where they had that Confederate flag flying, and they got a target there, and they're shooting right across to 138 with I'm a gun owner, but you don't bring guns to a party.
Right. Understood. Board members, Mr. Danielson.
Thank you, Mr. Chairman. Mr. Richmond, other than the complaint you filed with the building official, have you filed any other complaints since 2020 up until now with any of the other public agencies, police?
No, I have no issue with farming. We had a couple of cows there. We milked and goats and chickens and everything else, and the smell is not an issue to me. In 2009, Julie stood up and said that it was something to the effect of we had to put in our deed that if we ever sold our properties, it would be in the deed that whoever took it over wouldn't have to, put up with these smells and stuff, which she didn't mention anything about a campsite in 2020 coming.
So your testimony, if I have it correct, was that prior to 2020, you never saw any campers down there?
We had no issues, no.
You never saw any campers there?
Nope, they had the reenactment, they had the tents, and that was it.
I mean, we have testimony from the objector that they stayed down there during the summer, they slept there, they fished, they did this, they did that.
I did
and
hear that.
And your testimony is none of that existed until 2020?
The only one was Pam Hawksley. Pam Hawksley was a classmate of Gail's. We've had several class reunions at our place. She put a camper there for that night on the Cottrell property. And there hasn't been any. 2020 is when this crap started.
Okay.
I wouldn't be here tonight if it started 30 years ago.
Okay. Thank you.
Any other board members' questions? No? Thank you. Anyone else want to come up? Speak your mind. It's okay. Whatever you want to say. Just spell and state your name, please.
It's Gail Richmond, G-A-I-L, Richmond. I guess I just have to...
Do you swear to tell the whole truth and nothing but the truth?
Yes.
Please do. Yes.
No, I have to say, they do have these first weekend in fishing. They would have a gathering. They've had, graduation parties, school events, with their classmates, different things, and gatherings. As far as coming in with the campers at the way that they have these last... it was COVID. It was when they couldn't get into other campgrounds. Other campgrounds were closed because they used to go to other campgrounds. That's when they started coming. So it was in 2020, really, was the first. And when they came in, we went over right away and we said, what's going on here? Because when they came in, I want to say there's 4 or 5 campers in the pop-up tents, little cart that you pull and pop up, and other tents. And we said, what's happening? Because of the generators, the dogs and stuff like that were running all over our yard. And they said, COVID, we can't get into campgrounds, and we understood, and we said, we understand completely the kids have to have a place to go, but this can't be permanent. And then that went on all year. And they had several campers coming in, driving in and out all hours of the day and night, and it runs right along our property line, which we've owned the property since the 80s. My father-in-law owned it since in the 60s. So this 2009 was when we did we separated a piece from it, but we have owned it the whole time. It's not like we just moved in. And but what I was going to say is, so we went over and we asked them, what's going on, and they said the COVID. We understood, but that first year was horrible, absolutely horrible. We couldn't even sit out on our porch and talk because the generators were so loud. And you get just the routine noises of a campground and a gathering like this, yelling and the screaming and the kids and the dogs and, the traffic in and out. And we asked them to slow down. Some would be very good, very respectful. They would drive nice and slow, and then next thing you know, somebody would come flying through. Dust and dirt everywhere, blowing our way, And then the next year, when they finally left in the fall, it was like a godsend. And the next year, it was like this weekend, and all of a sudden they started driving in again. Same thing. So we went over, and Roy had tried to talk to them about the second year and even the third year. What can we do? This can't go on. This isn't a campground. And they had, the campers had Connecticut plates on, and it's not just their friends from there. And I don't care where their friends are from, but it's just the number. But he tried to say, why don't you move it to the other side? Go on the other side of your farm where the house is, a residence. You've got a pond down there. He said, I'll come down and clear the land for you. I'll help you do whatever you want. Just move it down to there. And they said, no, we like it here. So that's why, we tried to work with them and to try to talk to them a couple of times. And a couple of times they just turned and walked away from us, So that's why, we finally said, okay, we talked. We got a hold of, Roy got a hold of Julie through her husband, and a couple times, and talked to Glenn, and, he said, no, this is where they want to be, that's where they're going to be, we've done it before, and we're going to stay here. So that's when we said, okay, then, enough is enough. After going into our 4th year, we contacted Jamie, and we said, what can we do? This has got to stop, because it's just getting bigger and bigger, and worse and longer and longer. And they do go out to the fairs. They do the cattle showing, stuff like that, and they'll take their cows and go here and there, but they're coming back, and they come right back. And usually then in the fall, they pack up and they're gone.
Okay.
So.
Board members' questions for Ms. Richard? Okay.
All right.
Thank you very much.
If I may ask some points of clarification through the chair.
No, but we're all set.
Okay.
You can sit
All
down,
right.
and then you can ask us, and we'll see if we're going to ask the.
I would ask if there was in the discussions with the Cottrell family, if there was a discussion about the fact that the other ponds have historically been cow ponds and are not fit for humans to go into because of the fact that they're cows.
Yeah, use the mic. But I don't think where it is on the property necessarily is of relevance. It's more of the concern on our part is the fact that there were vehicles parked at this pond all summer with generators. And is that the case? Is that your? Because you didn't mention how long these campers were there during the summer, nor did you mention sort of any activity that was around these campers that were there, either historically or in a modern.
So Ms. Cottrell behind me can testify to the fact that once the issue with generators was brought to their attention, went out and purchased ultra quiet generators. Once the dog issue was brought to their attention, the dogs were given bark collars so that those issues would be addressed. It seems like the issues here relate more to noise ordinance violations and other ordinances versus campers being parked there. And I think there's, apologies, Mr. Chairman.
That's okay. Go ahead and finish.
And there seems to be a bit of a contradiction in what we're being told, whether there was nothing there ever other than until 2020, or if because there was, Ms. Richmond acknowledges that the parties were there on opening day for fishing, tournaments, and other aspects of it. So
sure,
there's sort of I'm speaking to my clients, there seems to be a feeling that there was no discussion, that the neighbors were sort of told, this is what we're doing. I don't think that's the vibe I'm getting from my clients.
Sure.
So if through the town or either directly, we want to have a discussion or an exchange and attempt to try to reconcile the situation, I'm very open to that discussion. As we said at the beginning, buffers, barriers, trees, other activities, we all do want to be good neighbors and try to work together.
Yeah, I guess it's just a matter of, in terms of what I've heard, is that there was occasional gatherings that happen around the pond, right? For years, for decades, occasional gatherings. And it sounds like, just by the testimony of the neighbors, that now it's a thing that just people are there.
I don't think so. From my discussions with Ms. Cottrell, and I'll put her back on to discuss, my understanding is from the start of the cow showing season, which starts in June through till mid-November, they are at least every weekend traveling somewhere for either a rabbit show, a cattle show. Do you do goats too, or a poultry show?
But that change. I mean, the occasional gathering, as opposed to sort of people parked there and 5 vehicles parked there, is much different than a historical use of people just using the pond for a birthday or using the pond for a special event. I mean, it certainly sounds like that there's been sort of an more of an intense use of the spot, which was already technically a violation in using that spot.
I would suggest to you that it's cyclical, Mr. Chairman, in that as the family has had younger children over the years, there's been more intensity, and as children get older, it's probably less. And then when they have children, the cycle starts over again, like most of the residential, generational cycles that we have in neighborhoods, et cetera. Ms. Cottrell has said to me, and tell me if I'm wrong, that this is an occasional activity, always has been and always will continue to be. Their animal showing and their 4-H schedule is their priority during the summer months.
So you're saying that what the neighbors have experienced in terms of people being out there from all summer to the fall is not accurate?
Well, I think what we heard was that they were there allegedly from the time of the Washington County Fair through the end. Washington County Fair is mid-August, so, and then the kids go back to school in beginning of September, so, and these folks all have residences and school-age children that go to public school, and they would be coming from their home to do that, not a camper.
But that's like that could be 4 weeks, 5 weeks of...
I would suggest more like maybe but again, that's what the allegation was, but I don't think that that's the case. But again, Ms. Cottrell will have to come back up and testify to that, because I can't do that. But I see your point, Mr. Chairman. I understand.
Because, I mean, and I think what the building inspector has been telling us is that there hasn't been a presence of vehicles adjacent to that pond. Just there's no documented evidence of a trailer being next to that spot for the past
on some years. Of the overflights, and that looked to me like they occurred more often in the winter than in the summer, and so that the foliage doesn't interfere with those overflights, especially in an era before modern cameras. I would agree with you. Doesn't show them in November and January.
Well, I think you can pretty much tell what's a building and what's a recreational vehicle in those photographs.
No, I'm not trying to imply that, but if those photographs are taken in November every year, or in December, or before the leaves come back on the trees in the spring, you're not going to see a transient camper that was used occasionally there, because of the nature of the fact that it's used primarily in the summer season. And it doesn't seem to me like those photographs have a lot of leaves on the trees and are taken during that season.
But, okay. I mean, you would think odds would be, if it was as regular as you're saying, that you would see something there more often.
Well, no, if we had photographs in spring and fall every year, like we did in the last couple of years, or the last year when they started to show up, versus prior to that when they were at most taken once a year or occasionally in gaps.
Right.
So I see your point, but I think that I don't know if the once a year overflight is the best barometer of it.
No, but I mean, but also you guys were saying that you were only having limited events down there. Like there were only like, some gatherings that happened near the pond.
I think it would be more that the family would recreate down there regularly, and then there were these bigger events that would come in as well. So to say that whether or not they built, for example, there was the little shack that was built down there. Whether or not family members went down, no one probably kept track of whether or not on a random Saturday night in August, whether they were sleeping down there or sleeping in the farmhouse or sleeping in a car. So to do that, we highlighted the bigger events that we had pictures of too. As we said, in a different era, people didn't have photographs at your fingertips and easily stored that would document these type of things like you would have over the last 10 years.
Nor would you have radios, generators, and other things that would break the peace.
If that's part of the issue, I think we can, again, those are discussions that I think are things we can discuss with neighbors. If part of the condition is going back to what it was prior with no generators or not electrified, I think I can make an argument that in the normal, it's like the argument of, well, the camper you had back then was a 10 by 12 camper. Well, they don't make 10 by 12 campers anymore. Every camper now has 3 bump outs and is blown out. So I parked my truck there, and my 91 Toyota pickup truck is a lot different than my 2017 pickup truck, and just, they're both pickup trucks, but times change.
Yeah, well, I think, though, our ordinance isn't against tents. Our ordinance is against recreational vehicles.
Okay, I understood.
And I think there is a big difference between how those two impact, sort of, but.
Understood.
Board members, question? Oh, of course, yeah. Anyone else want to kind of come up and speak, or anyone want to speak again? Go ahead, come on up. Again, state your name, spell it, please.
Hi, my name's Rich Collinson, Collinson. I live on 100 Acre Pond Road.
And you swear to tell the whole truth, nothing but the truth?
I do.
And you also had written a letter as well?
I did.
Okay, so go ahead.
The reason I'm here is that I love family history. Don't take it wrong. Family history is great. This is not about history. This is about a violation that's done on a piece of property, and if we don't do something about it now, it's going to get worse, because there's nothing stopping from the family getting bigger and bigger, and more campers coming in. You got to put a stop to it. It's as simple as that. That's right and wrong. And you guys are here to protect the people. That's all I got to say. Thank you.
But I mean, you certainly recognize that this has been used as a farm for many years, that they've had many gatherings there.
I went to school with the brothers. Mm-hmm. I played on that farm. There ain't no doubt about it. I don't have a anger bone against them whatsoever.
Sure.
But the situation is, it's cut and dry. It's black and white. Are you going to let them put campers on there or not? It's as simple as that.
Do you feel that it's changed in terms of how?
It has changed. Since COVID has come, there's been a gathering. I noticed this by driving down the road.
And gathering in what way? Like what kind
campers. That's all you see down the end of the field, like campers.
Okay.
And I can defend what Roy says. They can't go outside there at night.
Right.
Can't do it. Generators are running. The dirt from the people going up and down the road, it's not a paved road. It's all dirt from the fields.
Right.
So when they come up and down the road, there's dirt flying everywhere. Would you like that in your neighbor?
I mean, technically, they're allowed to drive on their property at any time.
I'm not knocking that. I am not knocking that.
As much as they want.
What I am knocking is that we have an ordinance in this town that you cannot do something. That's what we're here to defend.
Right.
That's all I can say.
Understood.
Thank you.
Okay. Board members, any other questions? Nope. Okay, thank you. Anyone else? Come on up. So again, just state and spell your name, please.
Trevor Richmond, R-I-C-H-M-O-N-D.
You swear to tell the whole truth and nothing but the truth?
I do.
Excellent, Mr. Richmond. Go ahead.
So I grew up next door, born in 1980, and I do remember them having occasional gatherings, little parties. I was a curious kid, so I'd always go over to see what was going on. I remember they had a camp out over the weekend in 2007 because it was interesting to me. So I see them here and there, but there is an absolute change with COVID. We're not talking about a little shack or maybe a tent and some kids fishing, but now we got 4, 5, 6, 7 campers there. The generators, even a quiet generator, that's a loud generator. There's not the cornfields to break up the noise, it's turf fields now. I know it's not about the noise or the barking dogs or those screaming kids all the time, which I want the kids to have fun. I don't want to sound like a Grinch, but it was an absolute change in 2020.
Yeah.
That's it.
Okay. Any board members, any questions? No? Okay, thank you very much. Appreciate it. Anyone else? Come on up. Sure, go for it. We only got one left after that. So again, please spell and state your name, please.
Michael Georgantis, MichaelGeorgantas.
Sorry. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Go ahead, Mr. Georgantis.
I'm just going to reiterate what Roy said. I was out sick last summer, and basically every time I walked the Richmond's property, I heard the generators running. And this is like in the morning, in the afternoon, and evening. And I understand, yes, you got a camper, you're trying to keep it cool. And then the issue with the dogs, I've been renting from the Richmonds since 2018. The 2 years before COVID hit, I do not remember ever seeing any of the campers out there. So the COVID hit, again, I'm walking my dog on the property, their dogs come running out, barking, not that they were going to attack, but they were running free, and I yelled out, there's leash laws in this town, and now they've, they keep them penned up, but they're still barking, because when I would walk by, because they're out in the heat, they're barking.
Sure.
And with the traffic too, up and down, nighttime, more so at nighttime that I remember. And then shooting off fireworks, which were more than just the kind you buy at like the 7-Eleven or something. And I also saw them, going back to what Roy said, I'm not a weapons expert, but I remember seeing them shooting at this board on these 2 posts near the flagpole. It didn't sound like a BB gun to me, but then again, I'm not an expert.
Mm-hmm.
So that's all I have to say.
Okay. Thank you.
Yep.
Board members, questions? Thank you very much, Mr. Georgantis. Anyone else? All done? All right. Okay, Mr. Sertief, is there anything you wanted to add to it, or anyone else wanted to speak?
Yeah.
Ms. Mayhew, please.
So they keep talking about 2018, 2019 for reference, because we do have such a big family. I had a newborn in 2017. My sister had a newborn in 2018, and then I had another one in 2019. Mm-hmm. So, and these were also not our first children. 2018 was my sister's third. 2019 was my second. So, and with our busy fair schedule, which I kind of want to explain because it sounds like we're there a lot. So our first show for the kids is the last weekend in June, which is the SRI 4-H fair. 2 weeks after that, we go to North Stonington Fair. That fair runs Thursday through a Sunday. Then there's about a 3 to 4 week stint. We might camp once or twice. Then we're going to go to Washington County. Washington County, our campers are there Sunday to Sunday. After Washington County, we're going to go to Brooklyn Fair. Our campers leave Washington County Fair, and they're going to go to Brooklyn Fair. After Brooklyn Fair, they go right to Spencer Fair, which is up in Massachusetts. That's Labor Day weekend. After that fair, it's time for school to start, so those campers go home. Then we're at Big E. And then after that, we're at this fair in Connecticut called Durham. And then after that, we might go once or twice. But again, my kids were super disappointed because we didn't get to do our fall camping this year. So if we would do, and they aren't really planned, because how a lot of our camping weekends work out is we look at the calendar and look at the weather, and then someone shoots out a text who wants to go to the pond. And then it's, okay, cool, you make dinner Friday night, I'll make lunch Saturday morning, that kind of thing. And we like plan it out, and the kids go and have fun, and the kids get to unplug. So I just kind of want to give you guys a little more perspective on like why there was a giant chunk of time. But like my after prom party for high school was there, and I graduated in 2010. So, and then I went away to college, and at that point my older brother was getting married, my older sister was getting married, and then babies happen. So there was a chunk, but basically 2020 is when got to the point where we're like, okay, wow, besides the fact that the world shut down, we needed a spot for our growing kids to be children. So,
And you guys didn't want to do it on another part of the property?
So there are other ponds there. The other pond by the house, that is a cow pond. Historically, cows were allowed in it for cooling themselves off, but honestly, that water hasn't been tested. It's probably not safe for my 5-year-old to go swimming in it.
Right.
The other pond, that is an irrigation pond, it's over 20 feet deep. Last time I was aware of the measurements, it's over 20 feet deep. Also, how with the irrigation pump setup, it's not safe for children to be swimming in that, because that's you're asking for an accident. And we purposely let the tree line grow up to basically create a very visible barrier as a reminder for the kids when they are on the farm, don't go anywhere near there, because it's not set up for swimming. The banks are incredibly steep. All it would take is honestly one slip from a kid or an adult who's not paying attention. And if you can't swim, well, I don't know what to tell you. Whereas the pond where we do swim, my husband and my brother-in-laws, they built a small dock where the kids can sit and they can fish and they can catch the little pumpkin seeds. We have their little paddle boat, and that pond itself is only like 14 feet deep, but the water does get tested, and it's some of the cleanest water in the state, which is really nice. It's so clean that we even have freshwater mussels growing in it, which is something that you don't see very often, and the kids love to dig their feet right into the sand and then pull it up and say, look what I found. And it's totally cool, because then it turns into a whole ecology lesson, and that's the stuff that gets me really excited, because besides the cows, I love ecology and love getting for those core memories, like I said, for the kids to have, to like know what it's like to dig in the sand on great grandpa's farm and find these mussels. But it's never been for weeks on end. We're too busy. Besides the fact that we also have the farm stand. As much fun as camping for weeks on end would be, it's not really possible. But like my sister, she's not here tonight. She did go out and spend $500 on dog collars to keep them out of the neighbor's yards when that was made a problem. $500 on a perimeter collar to keep them out once we were made aware. And they do have a run, and the generators run in the campers, one, to keep our food cold, but also so the dogs do have a chance to go in a camper to cool off when they are not outside, and also to rest, because they love to swim with the kids and chase them in the fields, and everyone's happy.
So, and what of the 4 to 5 campers out there at any one time? Is that possible?
When we're camping there, yes. But if you were to go out there in the middle of August, odds are it's not happening, because we're either at Washington County, Brooklyn, or we're going into Spencer Fair. Our children show all over, with all of our species they show from Maine down to Pennsylvania, Virginia, with 3 species, with cattle being primarily in the summer, whereas rabbits and poultry, we're in the middle of that season right now, but cattle is in the summer, and that is our passion in the summer months, is getting their cows out and going to the fairs.
And then why do you need more than one?
Because it's multiple families. I have 2 children. My sister has 3 children. Our other families who we've talked about, who were previous employees when the farm was milking, they all have 2 to 3 children.
Right.
And everyone has their own space for sleeping at night, and we're not on top of each other. And the campers do allow for things like cooking easier in case we do have inclement weather, in which I have a really cool rain video if you wanted to see from this past summer, sitting at the pond in the rain.
Right. So, but I'm still not, like, why not go to the other, like, why not have the campers on the other side of the property? Not next to where people are.
So we use that spot because that pond is safe to swim in.
Understand.
That's
but
basically it.
And is it true that prior to 2009, the residences were not as close to the pond?
Yes, they're granted their nice little ordinance in 2009 to move their property back. So.
Right.
And this has been happening, as you even heard them say, since prior to that.
But I guess when you didn't necessarily say that you were having 4 or 5 campers there since 1990.
No, so it started with like 1 or 2 with my parents, and then their friends.
Right.
And then my aunt and uncle. So in the 1990s, it was more or less 1 or 2 campers and maybe more pop-up tents, but times change, families grow.
Right.
And what's no longer 1 or 2 pop-up, instead of having 1 or 2 pop-ups with a lot of tents, now there's still 1 or 2 pop-ups, but there's maybe 2 to 3 larger hard-sided campers, but
with a lot of equipment to
no.
Generators
That are after we were aware of the noise, we went out and everyone went out and bought the quiet generators that are legally sold as quiet to be within noise ordinances.
yes,
So,
but still make noise.
Mr. Chairman, they do make noise. What I would suggest to you is it's a pre-existing non-conforming use. So the use is the family using recreational vehicles on the farm for their own personal use and enjoyment.
Yes.
Whether that's a singular camper, a pop-up camper, or a camper that was built in 1960 or a camper that was built today. And that's where I go back to my truck analogy. If I had the right to park my truck there in 1970, the truck I'm parking there is going to be today, if that same right has been maintained, is going to be very different than the truck I parked there when that right was created.
So you're saying that they would have the right to have 30 campers there?
No, I'm saying they would have the right to have their family and their core little group of folks without any commercial benefit to occasionally use campers on the farm for their own personal use and enjoyment.
But you can have 30 family members with different RVs that can go there under that scenario.
If there are 30, if the family suddenly got that large and they had employees and family members.
And you don't charge anybody, so why not?
But you can stretch anything, Mr. Chairman, and make it to a point of absurdity. And I guess I think that that's not what the parties have done or what their intent is. The intent is that the younger generation of the existing owners of the property, as that generation did when the prior generation owned it, uses a small portion of the premises with their own personally owned and operated recreational vehicles on the farm occasionally during the summer
all
seasons.
Rhode Island based?
I'm sorry?
All Rhode Island based recreational vehicles? Because they did say that there were some with out of state plates.
Yeah, because they bought it out of state and they had yet to transfer it over. It was like a testing weekend. That's why.
And so you would say that, but what is that point of absurdity? Because the testimony of the neighbors was to say that it used to be just a couple for a little bit. Now it's a lot for a lot longer.
Well, again, members of the family, if the family were to suddenly have 30 siblings, it would be like saying, how many people can I have? At what point does a family gathering become a block party? Well, how do we differentiate between those things? You have to apply a certain degree of common sense and reading something on its face.
Absolutely.
So I would suggest to you that if in the past the family members occasionally used recreational vehicles on the farm, that same use is continuing now. There's not been testimony that there's that there are strangers or that there are third parties, that there are other parties that are paying or coming in there for any purpose other than for family recreation around that pond and for family activities. So if the limitation if the issue is the equipment, I think with what the instructions Ms. Goins give you, you can put limitations on that and you can make a prohibition against that. If it's complete following of the Noid ordinance, you can make that a part of your prohibition or include that in a decision. You have the flexibility to address those concerns.
I'll ask, but yes, thank you. Thank you. Good. I don't want to stop you. I mean, if there's anything else. Nope. Okay. Thank you.
Let me ask the attorney, based on your argument. You stress family. Does that mean guests of family? Other people that are attending the fair that are invited to? How do you define family? Strict family members, guests? So, okay, so if the testimony supports that there's, which it seems to, that there's 4, 5, 6, 7 campers at a time, and now you're saying the family expands and goes to 25 or 30, maybe there's going to be 25 or 30 campers on the premises, wouldn't that call for possibly applying for a use permit? A special use permit? I'll ask the attorney. I'll ask our attorney that because. Well, if you're going to expand the use, if you maintain that the use has been established because there was campers there, and you're going to go to 25 or 30 in the future, perhaps, then wouldn't you need to expand that use legally? Well, I mean, you just made the argument that the family's growing. There could be 30 or 40 additional family members. I mean, you made the argument.
I didn't make the argument. I was trying to discuss what the chair said. My position is that it is not expanded beyond the number of family members and siblings that have been there, and that there's a bit of a cyclical nature of like any generational thing where the focus is on young children going out to the farm and recreating. That seems to be what the testimony is about.
Okay. Thank you. Okay, Ms. Goins?
Yeah, I can address that question about what are the parameters for a non-conforming use, and keep in mind the policy of our ordinance is to allow it to allow a non-conforming use to continue, essentially frozen in time at the parameters that it existed when it became non-conforming. And section 202 of our ordinance, 202, speaks to continuance of use, right? It can continue in existence. It can't be intensified in any manner. 202G, a non-conforming use of a building, structure, or land shall not be intensified in any manner. It goes on to provide some examples. Intensification shall include, but not be limited to, increasing hours of operation, increasing the number of dwelling units, decreasing the lot area, or increasing the seating capacity of a place of assembly. None of those examples apply here, but I think you can think about what does intensification mean. And then we know section 202 You see that all the time, applications, right? The beach cottages, special use permit for expansion of a non-conforming use. And technically, it's required for addition, enlargement, expansion, or intensification. And the ordinance states, the lawful non-conforming use of a building, structure, or land may be added to, enlarged, expanded, or intensified, provided that such addition, enlargement, expansion, or intensification shall not exceed 50% in excess of the existing floor area, land, or intensity used for the non-conforming use at the time the use became lawfully non-conforming. Okay, and the ordinance goes on to note that in granting those special use permits, you can place restrictions and conditions. So I think when you're considering the arguments, you can think about those provisions of our ordinance and determine how they should be applied to these facts.
When was the one RV per property brought in?
So just to remind the board, in 1976, the ordinance that's quoted in the notice of violation was in effect in 1976. So it was under a different section. It hasn't changed since that time. Short of there's some article from 1993 and some family photographs, but I haven't seen any clear, convincing photographs, evidence of any campers prior to 76.
Prior to 1976. So what you're saying is anything that occurred after 1976, unless it happened before then, is technically in violation of the ordinance.
Correct.
So it has to be prior to 1976 that we saw that things were happening at that site. And they said in the 70s the pond was built. So it just depends on, was it built?
Perhaps the pond was dug out, excavated, and filled with water, but were there campers parked there? Is there any evidence other than the owner's testimony?
Does anybody remember when that pond was built in the 70s? I know it's...
Any testimony should be on the record. Thanks.
If whoever knows, please come up and just restate your name, Ms. Richmond. Yes, please.
Thank you. I actually have the paperwork. It was from the Army Corps of Engineers. And I have to say, I think we were actually living there. We got married in 78 and we were living there just prior. So I'm going to say mid-70s. I was going to say 76. I do have that. I don't know if I actually even told you the date. I don't know if you... Yeah.
I believe it's included in the materials, the correspondence. My computer just died, the battery, but it is in the list of correspondence on...
I printed out their letter, and it was included with the letter.
I thought it, yes, I thought it was in there. Yeah.
Okay.
And then prior to that, there was nothing. It was...
So, if I asked this question before we started, or as we started, to say that thank you, Mr. If the pond was after the law, then...
That means there was a pond there.
That means the pond didn't exist before the law, which means that you wouldn't have had a vehicle there before the pond.
I think you're correlating the pond and the vehicles, but there's nothing to prove that they were established at the same time.
No, but I think you're suggesting that the activities seem to surround the pond, like the family activities of outdoor activities surrounded the pond.
My understanding is that prior to that pond being created, the family were still recreating and going about their normal activities and using it as a homestead and camping and using their camper. It just centralized and went to that location when the pond became dug out and turned into a nice swimming location. And that's sort of the reason why that the activities have been centered around that since the creation of the pond. I don't think we're not putting on that the creation of the pond was the first time the family camped or used a camper on the farm.
Right. But an RV before 76 was pretty rare.
I can't speak to that personally.
I mean,
I can't.
The movie Stripes was the 80s, but
I'm an 85 baby. I'm old, but not that old.
No, I mean, I guess I'm just trying to establish the fact that you know, recreating on the site obviously predates the pond. I mean, people were camping on, I mean, of course, people slept outside all the time, you know. So I think it's just a matter of the activity seemingly around the pond seems to be the biggest.
Yeah, Mr. Chairman, the board has every right to make a decision tonight, but we are very open to having a further dialogue with the neighbors and these folks to see if there is something that we can find that will satisfy them. And I know we may be past that point, but I defer to the board if you want us to go down that path.
From what I understand, I mean, the violation is there, so we have to rule on the violation.
If you're pressing the appeal, I think the board needs to make a decision. If you're either withdrawing the appeal or you're requesting that the hearing be continued, I think there's potentially room for, a get-together with the property owner and the residences, but unless you hear that request from the appellant, I think you need to rule on the appeal.
I guess I'm offering that as an opportunity to the neighbors, if they would want to have that discussion, if they're open to it. It seems like everybody wants to be good neighbors and historically were. This issue came up. I would agree to or think it would be prudent to go down that path, but again, I think Ms. Coyne hit the nail right on the head that unless that's a mutually agreed to thing here today, you probably have to make a decision.
Okay. Well, thank you.
Mr. Chairman, if I may.
Please.
This issue is relatively narrow. It's so narrow that we could have been out of here in 10 minutes.
Perhaps.
In my opinion, okay? Did on July 3rd a violation exist that the building official issued that violation letter for? That's all we're here for. On that particular date, did a violation of the zoning ordinance exist? All the other stuff we've heard can be dealt with the neighbors, with ongoing discussions, with what happens next. That's all we're here to hear. In my opinion, it is extremely narrow focus on which this board needs to deal with. And that is the letter of violation. Did that violation occur on that particular date? Whether it was corrected after or not is really not in our purview, in my opinion. Very narrow. That's all we're here to deal with. And I think we have testimony and we have documentation that supports making a decision based on that letter of violation.
I think the only caveat to that is that there can be the considerations which they're bringing up, which is if there was a non-conforming use, like if that did occur as a historical use.
I think you can and should consider that as part of your decision.
Okay. Anything else you guys want to add at this point?
No, Mr. Chairman.
Okay. You guys want to final words? Come on up, and then we'll discuss.
Roy Richmond,
Yes.
RICH-MOND. As far as trying to work this thing out, I did. I've talked to Julie, her husband, and I was told that Julie was against it and Matt was against it.
Against
having campers down there. This started in 2020. This didn't start. This way back is bullshit. This started in 2020, and they was against it. And so what the outcome was of that is the nieces wouldn't listen. They won't listen to anybody. So that's when I saw Glenn in the field mowing, and I said, I have excavation equipment. I offered to take my backhoe, go down to his pond, the other pond, which is clean. They irrigate out of it. It's always clean. And cut down trees, level out sites, whatever I had to do to put the campers in there. And he says, nope, they like it right there.
Okay. Yep.
So you know, like I say, I retired in this town of doing excavating. I kept some of my equipment. I've been burying cows for them since the 70s.
Right.
One year I buried 7 cows in one summer.
That's
how much money do
not a fun thing to do, I understand. So
for nothing. I've done thousands of dollars of work.
Absolutely.
Burying cows for zip. So,
okay.
I mean, that's not here or there, but I've been trying to be a good neighbor.
Sure. No, of course. Thank you. Appreciate that. Ms. Hicks, did you have a question for somebody or?
I do.
Excellent. Please.
Okay, I would like to take issue with something that I think you're implying, and yes, and that is that if the neighbors and the Cottrell family can come to an agreement about all of the issues surrounding the campers, that then it could be okay to have 6, 7, pick a number of campers on that property, if everybody sitting here is in agreement. My question is, isn't that a zoning violation? The zoning ordinance, as written, says 1. And it doesn't indicate it can be lived in, it indicates it can be parked there. So can any group of individuals, whether it's these people or anybody else in town, if they agree on something, can they violate the zoning ordinance? Just because they have agreed on it?
I would absolutely, to directly answer your question, no. But in this case, I would suggest that part of that would be an agreement as to what was there previously, and if and when it is a pre-existing non-conforming use, and how that use could progress to and culminate today in a way that doesn't impact the neighbors and doesn't impact my client, and allows the clients to continue the pre-existing legal non-conforming activity. So it's not, I don't think that anyone can just agree to violate an ordinance. I think that we would have to come to an agreement as to that the activity occurred previously, everyone acknowledging that, and then an agreement as to where the activity would take place going forward in the future. I hope that answers your question.
Okay. Thank you, Ms.
And my 2 cents on that, to answer your question from my perspective, I think at this point, the only way to, now that we're at this point, the only way to have a binding agreement like that would be through a consent order or judgment entered by the Superior Court. So the answer is no, private parties can't agree their way out of a zoning violation, and maybe communication could have solved the issue before we got to this point, but we're here now. So I think potentially there's room for an agreement, but as I said, unless the appeal is withdrawn at this point, or the appellant is asking the board not to make a ruling tonight, and I didn't hear that request, I think you have to rule on the appeal, and then whatever further judicial review might come of it, we'll see what happens.
Okay. All right, anyone else want to speak? Okay. So we don't have to close it per se, do we? No.
I think at a certain point you can cut off the public hearing and move to deliberation.
Nobody's jumping out of their seats, I don't think. So I wanted to have a discussion and see what everybody's kind of thinking. If it's more comfortable, I can go first. We don't have to, unless they're jumping up. Okay. So I don't know if somebody wants to go first. I'm more than happy to, but Mr. Daniels, if you wanted to.
I'll go ahead. I think I made it pretty clear. I think it's a narrow issue. I've heard nothing that convinces me that this was a non-conforming use that goes back years. I've heard no additional testimony other than the applicant's testimony, which is obviously favorable to them. I've heard no witnesses come forward for the applicants, but I've heard a number of objectors indicating that, in their opinion, this violation existed and continued to exist after 2020. So again, to me, it's a narrow issue. Was on this date a violation observed and a letter of violation indicated based on the fact that there were 3 campers on the property. That's what the condition indicates, when there should have been 1 based on the ordinance. And I've heard nothing that convinces me that the building official was wrong, and I would uphold the letter of violation that was issued on that date.
Thank you, Mr. Daniels. Mr. Rosen?
Yeah, well, I sat here as a listener for most of the time, and my thoughts are that I can accept the grandfathering in of the appellant, that there indeed was activity that went on there within the ordinance. That is, there weren't any campers there through till the COVID hit. And then when COVID came along, the number of campers started to increase. And so if you take Amy's description of what grandfathering means, it means that it's frozen in time. And if you take that argument any further, you would say that there really shouldn't have been any campers on there at all, but the ordinance allows 1, and so they could bring that camper in. But after the COVID came, there were obviously more campers there, whether it was just for the weekend or whether it was for the entire summer, where they just left the campers there and went off to different fairs or whatever they were going to do. That's beyond the reach of this board. I happen to agree with Mr. Daniels that the issue is really very narrow. What happened on July 3rd? There was more than 1 camper there. That's when Mr. Gorman came, assessed the situation, and wrote the letter. And with that as the background and the narrowness of the issue, I would tend to uphold his decision.
Thank you, Mr. Rosen. Mr. Diamond, you got some thoughts?
Yeah, I echo all of my colleagues' comments this evening. I think this issue is quite narrow. I definitely support the building official's issuance of the violation.
Okay. Ms. Hicks, you want to?
Yeah, I have nothing else to add.
Nothing else to add? Mr. Elliott?
Yes, I couldn't agree more with Mr. Daniels' assessment. I think he hit it really head on. It's more of a black and white issue here. I had some concern with the conflicting testimony of the amount of time that the campers were being used. But irregardless of that, I think this is really a black and white issue of what the zoning officer saw and witnessed as opposed to what is allowed. So I'm not a voting member, so I'll leave it at that.
Your voice matters, so thank you. So I agree with my colleagues. I think, what I really wanted to know was sort of the use of the property and sort of how they've been sort of conducting themselves as farmers for the past 100 years and plus years. And obviously they would use it, the family would gather, they would have many gatherings, they would have parties, they would have people stay there, and I mean that is all part of the life there, because obviously you cannot run a farm alone, and usually have larger families. So I think that certainly there was times over the years that gatherings have happened, and perhaps more than one RV had been there for those activities, which I can certainly see as not only part of the family life there, but also some of the activities of commercial activities. But it does sound like, since they had neighbors there since the 70s, that clearly over the past few years there's been an intensification. And I think it was understanding sort of how that is defined, that sort of sort of solidified my judgment that our building official had made the proper violation notification, that this is indeed more than what had been there in the past. I think we can certainly discuss differences of the type of things that people sleep in and the noises they make, but clearly it's more. So I think it's fairly unanimous up here, and that we all believe that Mr. Gorman was correct in his assessment. So I would ask Ms. Goins to draft something for us to vote on by the next meeting.
And can you make that as a motion?
I
I would say the motion in order would be motion to deny the appeal, and with direction to legal counsel to draft a decision for the board's review. We do have a meeting scheduled next Wednesday. I'm gonna try to get you a decision for review before 7 o'clock next Wednesday. It may not be much before 7 o'clock next Wednesday, but I'll have a draft decision for you to review.
And I mean, even if we're at the meeting, that's okay, because
Yes.
we can have a
Yep.
chance to review it
Yep.
during the meeting.
Just to clarify, Mr. Chairman, we don't need an additional finding of fact, correct?
Here's what I'm gonna do. I heard your comments. I'm gonna write up the decision, sufficient to enable further judicial review if needed.
So I'd like to make a motion to deny the appeal of Cottrell Homestead of 500 Waits Corner Road. And I would ask that our attorney sort of draft the motion to be voted on by the next meeting. Can I get a second?
Why can't we vote on it tonight?
Because we don't have the decision.
You're voting tonight, but I'll be writing it up in a written decision. That way, if the appellant wants to take it to Superior Court, the decision is sufficient for judicial review, right? So I'm going to distill your comments down into findings of fact and conclusions of law.
Yes, it could be much more succinct. So, second by Mr. Daniels, was that? Any other discussion? Hearing none. Mr. Cagnetta, aye. Mr. Daniels? Mr. Rosen? Aye. Mr. Diamond?
Aye.
Ms. Hicks?
Aye.
Okay, motion passes. Okay, thank you very much.
Thank you, Mr. Chairman, members of the board, for your time.
I appreciate it. Thank you. So we had a... Two more things, or one more thing? So the approval of the November 15th, 2023 minutes, for those that had any chance to review, anybody have any changes, recommendations?
No, they look fine.
They look great. Are you kidding me? Okay, all in favor of passing those minutes from November 15th? Aye. We have a meeting next week. Anyone not going to be here?
I will not be there.
What? Come on, this one was so good.
I know, I
dare you. Okay.
would like to be there, but I will be in Arizona while you are up here.
Good for you. So, and next week is is the other Kevin going to be here? Okay.
What's the
I'm sorry,
time?
man. You'll get a chance to vote. Don't.
7, not
o'clock.
6 o'clock.
No.
Okay.
Okay,
7
thank you.
o'clock.
Thank
Thank you.
I can't tell you how long I sat here thinking that I'll never have a chance, but we used to get candy. Sure, bring it. You got to show up though. So we have work sessions regarding South Kingstown boards and commissions. Just so you know, I did speak with Jamie about this, and we didn't feel that the zoning board had anything that was really outstanding that we felt that we needed to present anything to the town council we felt that everything was sort of run along just fine. But, and there was only so much room on the schedule too, but it doesn't seem like that there was any need for any changes. If anyone thinks that there's any needs, Mr. Daniels, I would like you to submit your changes. No. So if anybody does feel like that there is something that we need to do, please feel free to bring it up. But other than that, I think we're all done. So, motion to adjourn?
So.
All right, all in favor? Aye. Excellent. Great job, everybody. Thank you very much. I get afraid that I know that people are going to go